Good morning, and welcome to the Committee on General Welfare, jointly with Public Safety and Oversight Investigations. At this time, please place your phone on vibrate or silent mode. If you want to send testimony, send it to testimony@council.nyc.gov. Once again, that's testimony@council.nyc.gov. At this time, during the hearing, do not approach the dais. Thank you for your cooperation. Chair, we are ready to begin.
Good morning, and thank you, Sergeant. This committee is now beginning. I am Gail Brewer. I'm chair of the City Council's Committee on Oversight and Investigations. We're holding today's hearing on the rising tide of operational dysfunction that threatens to overwhelm our city's family courts. I think we all know that even in the best of times, family courts are tasked with the enormous challenge of intervening in the most intimate aspects of people's lives to ensure children's safety and well-being. The task of the court becomes nearly impossible when there's inadequate staffing, inflexible hours, inhospitable facilities, and poor use of technology because they drag out very sensitive cases. Delay extends what can be a traumatic experience for our children, while the stop-start movement of an opaque and unaccountable system can leave parents feeling like they have been processed by an impersonal machine rather than serve justice. These issues made family court a frustrating experience before the pandemic. But since 2020, the institution has, I feel, dipped into crisis. Judges, attorneys, caseworkers, and staff and related service providers uniformly report that the institution has broken down. Delays are universal. Staff are increasingly difficult to recruit and retain. I know that's across the board, but it's particularly important in this court. Caseloads have spiked, and the courthouses, particularly two of them, have deteriorated. The inability of the courts to function in a remotely efficient or humane manner adds insult to the injuries many children and parents face when moving through the system. As we know, family court is run by the New York State Unified Court System, not the City of New York, although the city has many aspects to the courts. So there are limits as to what the City Council can do. But city agencies perform vital duties as part of the family court, and when they fall down on the job, the legal machinery grinds to a halt. For example, when a caseworker for the Administration for Children's Services, ACS, cannot file a report on time, judges can't hold proceedings, cases are delayed. When the Department of Citywide Administrative Services, known as DCAS, fails to perform basic maintenance on the city-owned buildings that family court rents, the facilities are impediments. Today we're going to ask ACS, the Law Department, the Department of Probation, and DCAS, and maybe by extension, the Office of Technology, how they work with family court and whether they have resources or protocols to make sure they do not unnecessarily contribute to delays. We want these agencies to contribute to the family court's improved functioning, not become obstacles. I think we know that there was a report from the state's Franklin H. Williams Judicial Commission and the New York City Bar Association as recently as last December. And they suggest that the city has not been an effective partner for the courts. It was a very extensive study. I would like to thank the Oversight and Investigations Committee staff, Legislative Counsel Nicole Cotta, and policy analyst Alex Yablon for their hard work. I would also like to thank members of the Council's Oversight and Investigations Division, Director Aaron Mendelson, Counsel Kevin Frick, Legal Investigator Zachary Maher, and Investigator Katie Sinise, as well as Sam Goldsmith of my office. I do want to indicate that I did go to the family court in Manhattan. I know staff has gone to almost all the courts. And what you see is a beautiful new building, family court compared to the other buildings, but there are operational challenges, including the Wi-Fi that doesn't work. It works in some areas, not others. When we were watching a proceeding, it didn't work. It stopped in the middle of a case. And that's not a good thing. And there's lack of adequate staff in the courtrooms. As you know, they have different lack of overtime compared to other courts. That's a problem. And of course, bleak courthouse facilities. So I want to thank everyone who's going to be here today, and I'm going to turn it over to my colleague, Councilmember Diana Ayala, Chair of General Welfare.
Thank you, Madam Chair. Good morning, everyone. My name is Diana Ayala, and I am the Deputy Speaker of the New York City Council and the Chair of the General Welfare Committee. I'd like to begin by thanking everyone for joining us this morning for our joint hearing with the Committee on Oversight and Investigations, the Committee on Public Safety, and the Oversight and Investigations Division on Operational Challenges in Family Court. Much has already been said by my colleagues regarding the overreaching themes that we would like to address at today's hearing. I will not repeat, but I will hone in on the fact that at the General Welfare hearing last month, we heard from ACS that approximately 137 family court legal services attorneys practice in family court. The administration reported that in fiscal year 2023, 26 attorneys have been hired. Commissioner Dan Hauser followed up with me afterwards and indicated that the agency anticipates a new class of 45 attorneys to start in the fall of 2023. It is not surprising that there are struggles to hire attorneys, given that their compensation has not increased since 2004, and given overloaded cases making burnout a sad reality for those who would otherwise remain in their jobs. What has this translated to for families across New York City? It means unnecessary delays in adjudication of many cases, including those involving orders of protection for violent behavior. It also results in the unnecessary re-traumatization of children. For many children appearing in family court, it is one of the most traumatic moments of their life. It should not be that children need to experience this or that they end up having to start from scratch with the new attorneys due to a mass exodus of those who leave their jobs due to low pay and long hours. Yet, this is the reality of our system. The national average for lawyer representing children is between 40 to 60 cases per attorney. Let me repeat that again, 40 to 60 cases per attorney. While in New York, the caseload cap for each attorney is 150. This is outrageous. Today, I would like to hear how the administration plans to address some of these issues that result in these inefficiencies, including current staffing, funding levels, caseloads, and case delays. I want to thank the administration, the advocates, and all who have taken the time to join us. Finally, I would like to thank the committee staff who worked to prepare this hearing, Mensa Kilawan, who's our senior counsel, David Romero, counsel, Austria Chan, finance analyst, Lisette Gandia Diaz, legal intern, and my staff, Elsie Encarnacion. I'll turn it over to Madam Chair.
Thank you very much, and now we'll hear from Camilla Harris, who is the head of public safety. Madam Hanks.
Thank you so much, Chair Brewer, Chair Ayala. Good morning. I am Camilla Hanks, Council Member and Chair on the Committee of Public Safety. I welcome you all today to the joint hearing on the operational challenges facing our family courts. I would like to acknowledge my colleagues, Councilmember Gail Brewer, Chair of the Oversight and Investigations Committee, and Deputy Speaker Ayala, Chair of the General Welfare Committee. I would also like to thank our respective staff members for putting this important hearing together, and I would also like to acknowledge council members who have joined here today, Councilmember Lee, Brannan, Hudson, and Osei. Today's hearing focuses on the critical role of family courts in our society. These courts address the range of vital issues, including the welfare of children and families, providing justice to victims and offering pathways for those who are struggling. As someone who has dedicated much of my career to improving the lives of children and families, I know firsthand the difference that a properly functioning family court can make. However, a poorly operated court can lead to injustice and suffering, which could adversely impact the families they seek to help. It is therefore essential that we assure that these family courts have facilities, staffing, technology, structure, and support they need to fulfill their vital mission. As chair on the Committee of Public Safety, I hear every day how important it is to keep people out of the criminal justice system and family court that can serve as a stopgap to achieve that goal. By providing support to those who are mistreated, neglected, abused, and or otherwise not properly supported, the family courts can help to ensure that they receive the help that they need. Thank you to everyone who has come here to testify, including the members of the judiciary, city agencies, attorneys, advocates, and all those who have been impacted by the courts. I look forward to joining my colleagues for a productive and informative discussion, and I'd also like to recognize my committee staffer, Councilmember Caban has joined us. Thank you so much.
So now we're first going to hear from Justice Ann O'Shea, retired acting Supreme Court Justice. Would she please come up? And also, we're going to hear from Sandeep Kandari, who is going to, both of them are going to testify. He is from the Center for Family Representation. Then after they testify, any questions will be heard, and then we will take a 5-minute break, and then we'll hear from the administration. Thank you both for joining us, and Justice O'Shea, if you'd like to begin. Thank you.
Oh, sorry. Can you hear me now? Okay. I'm an retired acting Supreme Court Justice. I served for about 16 years in family court in Brooklyn. I thank the committee chairs, Gail Brewer, Camilla Hanks, and Diana Ayala, and the members of the Oversight and Investigations and the Public Safety and the General Welfare Committees for focusing attention on the challenges of family court. These hearings are crucially important because the public usually only hears about family court when a tragic case of abuse ends in the death of a child, and that makes headlines. Fortunately, those cases, spectacularly horrific cases, are rare. There is a lot to say, and I'm going to, I know time is short, so I'm going to try to talk fast. But aside from this, the horrific cases where a child ends up dying, hidden from public view are the workings of the court and the hundreds of cases in which children are removed from their homes and families, taken into custody by the Administration for Children's Services, and placed in foster care with strangers, too often without cause. My testimony focuses particularly on the child protective aspect of family court. Countless studies have concluded that removing children from their homes and families, even brief stints in foster care, results in often lifelong trauma to children. Although the removal of children from their homes is supposed to be reserved for circumstances that present a, quote, imminent risk to the child's life or health, 75% of the removals are actually based on neglect, not abuse. And neglect is defined by the Family Court Act as the failure of a parent or person legally responsible to supply the child with adequate food, clothing, shelter, education, or proper supervision. Rarely does a parent intentionally fail to provide his or her children with the basic necessities of life. These circumstances arise from poverty, the unavailability of adequate, safe, affordable housing, and a lack of supportive resources. Poor, marginalized Black and brown communities are disproportionately targeted for alleged neglect stemming from poverty. New York's child welfare system does little to address these root causes of poverty-based neglect. It is a child protective model of child welfare that protects children only after they have been hurt. It is reactive, focused on the protection of children, again, only after they have been hurt. It is investigatory and prosecutorial rather than supportive of families in trouble. It is a system that relies on surveillance of families by mandated reporters, the too frequent removal of children from their parents and their homes, and the transfer of care from parents to foster parents. It is a system that offers inadequate services before and after a report of suspected abuse, of neglect, or abuse has been received. It is focused on the gathering of evidence to prove wrongdoing by parents, pits the state against families in adversarial proceedings, and punishes and stigmatizes parents. It does not have to be this way. There are other child welfare models that provide preventive, supportive, wraparound services for children and families that are embedded in and realized through private and governmental educational, medical, and social service agencies. These kinds of child welfare models are referred to as family service systems and are employed in other countries. These models are also mirrored in a number of legal services programs, such as the Brooklyn and Bronx Defenders, and the Center for Family Representation, which represent parents and children in New York's family courts, and which provide their clients with services of lawyers, social workers, and other supportive services. Sandeep Kandhari will describe for you the wraparound services that CFR provides to its clients and how they benefit from such services. Many of the operational problems of family courts stem from the nature of the child welfare system in which we operate. Many of these challenges have plagued family court for decades, and many are not problems of the family court's making, but arise from the failure or inability of other agencies that are involved with child welfare to fulfill their responsibilities or to coordinate with other agencies to provide necessary services for struggling families. For example, family court is the busiest, most under-resourced court in the system. The state legislature has not seen fit to create enough judgeships to adequately meet the needs of the litigants or the court. At one point during my tenure, I had over 1,000 cases on my docket. The Mayor's Committee on the Judiciary is notoriously slow in filling vacancies for a court that has not allocated sufficient judges to begin with. My understanding is that currently there are 9 unfilled family court judicial seats. Filling them could go a long way toward providing services for the families that come. OCA attempts to fill the deficiencies in the number of family court judges by assigning newly elected civil court judges to the court for 1 or 2 years. Most of those judges have little or no experience with family court and have to play catch-up to even begin to adequately adjudicate the complicated cases that come to them. By the time they are getting their sea legs, it is time for them to move on and be replaced by a brand new crop of temporarily assigned civil court judges. In my view, this is grossly unfair to both litigants and the judges. There are not enough lawyers, and the lawyers who do appear in family court are torn in many directions. I could only try cases in blocks of 1 or 2 hours because 1 or more lawyers on each of my cases had to be before a different judge in a different proceeding thereafter. Finding a date and time when all the lawyers could appear to continue the trial or hearing would often take 15 or more minutes from my already limited time. While I understand that the recent raise in pay for 18B lawyers has somewhat staunched the outflow of lawyers from family court, the increase in compensation is insufficient to attract new 18B lawyers to family court who face extremely difficult, complicated, and emotionally draining cases and a highly stressful work environment. To be a lawyer in family court requires an extraordinary level of commitment to the children and families who appear in family court. Although family court judges have far more cases than Supreme Court justices, they are allocated far fewer resources. For example, every Supreme Court justice is afforded 2 court attorneys and a secretary. Family court judges with much larger caseloads are permitted only 1 court attorney and 1 secretary for every 3 or more judges. Chronic shortages in support staff cripple the ability of family court to provide timely and appropriate justice for children and families. My former colleagues report that 25% of the positions lost during COVID remain unfilled, compared to 8% in other city agencies. That includes crucial positions of court clerks and court officers. Proceedings cannot go forward without or be adjudicated without court officers and court clerks. DCAS is woefully deficient in the repair and maintenance of the family courts in the Bronx and Staten Island. I have heard reports that when it rains, water leaks onto the bench of one of the Bronx judges. I cannot imagine that happening in Surrogate or Supreme Court. The permanency plans that are devised by foster care agencies are frequently ill-conceived and require parents to engage in programs that are unrelated to alleged abuse or neglect. For example, requiring parents to submit to regular drug testing when the stated basis for the petition is a dirty home. Too often, ACS places remove children in foster homes far from their families' homes, necessitating changes in schools and making visits with their parents or caregivers extremely difficult. In one of my cases, 3 young boys were removed from their wheelchair-bound grandmother's care and placed in separate foster homes in the Bronx. When the grandmother took the subway from Brooklyn, where she lived, to the Bronx to visit her grandsons at the foster care agency, she discovered that the subway station for the agency had no elevator. She returned home without seeing her grandsons, and they missed their grandmother. Similarly, the Department of Homeless Affairs too often assigns families to housing far from where the family was previously living, again necessitating changes in the children's schools and a profound instability in the lives of the families who have been rendered homeless. There is a chronic shortage of services such as supervised visiting programs, parent education and job training programs, counseling, and other programs that are needed to address the problems that gave rise to the allegations of child abuse or neglect, with the result that children languish longer in foster care while their caregivers languish on waiting lists for services. Family court judges are too frequently required to try to remedy the failures, missteps, or lack of coordination among other governmental agencies, which takes away time from their responsibility to decide cases. What I have related to you today cannot begin to describe the anxiety and fear experienced by families and children who are caught up in the child welfare system. What I have told you also does not begin to describe the commitment, dedication, and hard work that is shown every day by the judges, court attorneys, clerks, court officers, lawyers, social workers, secretaries, and other support staff, as well as many ACS and other agency employees who toil away in family court. I thank you again for the opportunity to talk about a court that I loved being a part of and will be happy to try to answer your questions.
Thank you. Mr. Kandari? Before you start, Mr. Holden, Councilmember Holden has joined us, and I feel terrible about chairs. Are there any other chairs for the 3 individuals who are standing there, or 2? One of them is a former judge, family court judge. Councilmember Ung has also joined us. Judge, why don't you take it? He's a former judge. Go ahead and take the chair, sir. I'll feel better.
Thank you, and good morning. I want to thank you all for allowing me to speak on behalf of the children and families we represent every day at the Center for Family Representation, also known as CFR. I also want to thank Justice O'Shea for her important comments today. My name is Sandeep Kandari, Director of Litigation for CFR's Youth Defense Practice. I've been representing young people in family court since 2006, and I have had the privilege of working in all 5 boroughs over the course of my career, so I'm very familiar with how the system treats our families and children. CFR uses an interdisciplinary practice, which means that every client who meets us, adult or youth, is assigned both a lawyer and a social worker from the first day we meet them. This model is why I joined CFR, because I've seen how many different systems are involved in our families' lives, and that providing social support is just as, if not more important, to helping our clients avoid ever coming back to court. Now, as your committee considers ways to improve family court, I want to focus your attention on a few issues. First, children who are removed from their families and placed in the foster system are not doing well. The citywide high school graduation rate is 77%. Now, that rate drops to 60% for children who don't have stable housing, but it is only 25% for children in ACS custody. Think about what that says about the quality of care ACS is providing for our most vulnerable children. ACS has deemed these children victims of neglect or abuse, but then chronically fails to provide the support they deserve. Too often, teenagers are deemed hard to place and languish in the children's center or in youth residential centers, where they are not only displaced from their families, but also from their schools. The Children's Center in particular is not an appropriate placement for teenagers, but there are so few placements for adolescents who exhibit behavioral problems, so they will have to stay at the Children's Center because there's nowhere to send them. The Children's Center doesn't have a school on site, there's no programming for children, but teenagers are not even allowed to have their cell phones during the day. So what are they supposed to do all day as they wait for their long-term placement? Too often, I've met with children in ACS custody who aren't being provided support in going to school, having their special educational needs reviewed or enforced, and these destabilized children sometimes get arrested when they don't have the appropriate services. Family court refers to these children as crossover cases because they have simultaneous family regulation and juvenile delinquency cases. Too often, when these children get arrested, they receive far less support than I see from children who live with their families. Caseworkers often fail to go to the precinct to speak with NYPD, and often nobody even comes to court when the child is brought before a judge. An ACS liaison who is already working in the family court will arrange for transportation for the child to be brought back to their facility. Sadly, from my experience, the caseworkers who do appear in court often share negative information about the child, acting more as an arm of the government rather than a support for the young person. If the child is 16 or 17 when they're arrested for a felony and under raise the age brought to criminal court, there isn't even an ACS liaison in that building, and often nobody appears for the child and nobody's there to pick them up. In sum, ACS is not a very good parent for adolescents and then doesn't do enough to support them when they get in trouble. Now, I also want to think about the effect of the pandemic. As we're thinking about how we can best serve children and families, I direct the committee's attention to think about the impacts of the pandemic on our young people, especially those with the greatest need. By some estimates, as many as 59,000 children have fallen out of the school system but aren't registered as homeschoolers, nor have they moved. They've just stopped going to school. That's a staggering number of children, and young people out of school are more likely to get arrested. There's also a false narrative being propagated by some that children are committing more violent crime than ever. That is categorically false. Everyone should read the John Jay's report from February of this year, but the rates of children are actually lower than they have been in the past 2 decades. There was a spike in youth and adult gun violence in 2020 and 2021, but that has largely subsided. Our client families come from the poorest and most neglected communities across New York City. Communities with failing public housing, inordinate gun violence, and the highest rates of COVID deaths. These families need our support. I've spoken with so many parents who believe their children are struggling with mental health needs, and they don't know where to turn. Parents who are seeking support for their children in the richest city in the country should be able to find it. I don't want their children to have to get a court case before they can get family therapy, nor should the first mental health evaluation they get be from a court-ordered psychologist. But the wait times to get evaluations can be weeks or months. There are not enough mental health counselors available in our poor communities, and unfortunately, these services are just hard to attain. As your committee seeks ways to improve court operations, think about what these families truly need to avoid coming to family court altogether. Many need stable housing, others need access to mental health services, many need better school placements for their children with special needs, and many parents simply need affordable childcare so they can help their older children. We need to help poor families get support outside of court. Since Raise the Age started having 16 and 17-year-olds appear in the youth parts, there's only one alternative to incarceration program available called Esperanza. Sadly, Esperanza lost their funding this year and have recently shuttered their operations, leaving children in the youth part without any services available through court other than probation monitoring. In family court, we have a few more service options available, and I'm grateful for the programs we have. I ask the committee to think big because we are in an era of change post-pandemic. I'd also urge you to consider your funding priorities outside of this hearing to improve access to mental health services for families. Adolescents are struggling and need access to good mental health services that also work with their caregivers so they can better support their children, ideally at no cost. The City Council needs to do more in the communities where our families come from. We need to invest in community providers so that the families can trust the services they're receiving. A courthouse is not the most conducive environment for understanding people. If the council is going to add funding to family court, your committee should fund an educational advisor who is placed in family court akin to the DOE Welcome Center to help families better understand their rights and options for their child's education and to help them get the appropriate school placement. This service should be available to any family that comes to family court. Finally, when it comes to crossover youth, children in ACS custody who incur juvenile delinquency cases, I believe our city has the deepest burden to serve them. I don't believe any teenager should ever go to the Children's Center. I also believe that any child who is arrested while in the Children's Center should have their case automatically diverted by the Department of Probation, and the main goal should be to connect the young person to an appropriate school setting and supportive services. These children cannot be seen as a victim at 1 minute and then immediately turned into a perpetrator the next. We have to do better by these children. Now, ideally, we can avoid separating them from their families by providing support for the families as early as possible. I don't want our city to continue throwing money at the same agencies who have been running things for years and expect better outcomes. We need to think bigger. Thank you for listening. I'd be happy to answer any questions.
Thank you both very much. Councilmember Caban, did you have questions for these folks or for the administration? Okay, go ahead. Yep, go ahead. Yep, all right, I'll get to you. Thank you. Go ahead.
Well, thank you, and thank you for being here. Thank you for your service, Judge. Thank you for the advocacy that y'all do over at CFR. You do incredible work. I know that you spoke about this, Judge, and it reminded me of something that way back, not that far long ago, but Bronx Family Court Judge Sarah Cooper spoke about this in the past. And I remember she gave, I can't remember in what context, but
I'm not hearing you.
Sure, can you hear me okay?
Yeah.
Okay, so
Talk more slowly, Councilmember
you got it.
Caban.
Bronx Family Court Judge Sarah Cooper, I think this was a few years ago, but she made this statement around sitting on the bench as a judge and making these super consequential decisions around whether to separate children from their families. And I appreciated your testimony because I felt like you touched on this a bit. And she said that she felt completely ill-equipped from a professional experience, training, expertise standpoint to make these trauma-informed decisions about when and where and whether it was appropriate to separate children from their families. And you noted some of that in your testimony, right? There are these immensely consequential decisions that are made. And so my question for you is, what resources do you have, do other judges have, to understand which of the two would be less traumatic in a given instance?
Which is the what? I'm sorry.
Which would be, like, in terms of making that consequential decision as to whether to separate a child or children from their family, right? What resources were available to you as a judge? What resources are currently available to sitting family court judges so that they are better able to understand which of the two options, keeping families together or making that deeply consequential decision to separate families, which would be the less traumatic decision to make in that given instance? What tools do y'all have? What resources? What training?
Well, I think one of the problems is that the resources are scarce and limited. When it depends on the allegations that are made. When it's a question, for example, of a dirty house, sometimes described as deplorable, I don't think the solution is to remove a child from the home. I think a solution would be to get a cleaning service in there to clean it up, to teach the parents how to keep the house clean, to give them the resources to do so, and to provide a safe and sanitary home for them. When it's even excessive corporal punishment or corporal punishment, I think the solution is not to remove the children from the house unless it is extreme, unless it is really excessive, because the removal of a child is often more traumatic and more damaging than the corporal punishment. I know that that's in some ways it's sort of counterintuitive. However, I think that the real damage to children, the long-term damage, really comes from removal when that's not necessary. Give those parents and teach them how to discipline their children in a way that is appropriate. I think many of our parents never had that kind of role model. Many of the parents didn't know any other way other than through some corporal punishment. And it's all, I wish that they had that kind of resource before the fact, before the report, but that's not available in our system, or at least not much. So I think you have to address, if it's a drug or alcohol program, provide the support in the drug treatment programs that are necessary, but do not necessarily remove the children from the home. I think the system in ACS and most of the agencies that work in family court are very risk averse. And I understand that people are very nervous. Nobody wants to be on what used to be called page 6 of the Post because something happened to a child. But I think of a use of good judgment and by the judges, by the caseworkers, and by ACS, by the lawyers in ACS, by the case managers in ACS, really is required, not to take into consideration the damage that is done from removal and weigh that against the potential damage of leaving the children in the home with the alleged neglect that's
And I have a couple of quick follow-ups.
Quickly, though, because you got many more people want to
promise,
very
thank you.
quickly.
I think one thing that you mentioned, sort of the distinction between, like, what is, you know, the difference between, you know, imminent risk and abuse and neglect, and then kind of this idea that, you know, it's not all about personal responsibility, but systems and how we fail or lack support to families to be able to provide the homes that they'd like to be able to provide for themselves and their children. But my follow-up to the question is, you know, I'm aware of the Strong Starts Court initiative, which I know grew out of Bronx Family Court. Would you be able to explain that initiative, and if you have any knowledge around it, share any outcomes or metrics of success or plans for expanding or improving the initiative?
I'm not sure that I can answer that question. I mean, certainly not in the time. Again, it's the use of good judgment and weighing, you know, whether the damage done through removal is greater than the damage done by the parent, and how you can solve the problems that are presented in that family without the drastic remedy of removing children.
Thank you, and thank you, chairs.
We've been joined by Council Members De La Rosa, Joseph, and Ariola, and I know Council Member Hanks has a question.
Thank you so much, Chair Brewer. Thank you so much for your testimony. As someone who has worked with adjudicated young people in my career, your testimonies were powerful, and I appreciate them very much. So you testified that a child who is arrested in the Children's Center should have their case automatically diverted to the Department of Probation with the main goal of connecting young people to supportive services. So we have an interesting opportunity when these young people are criminally justice involved and in the courts. And we have this opportunity to give their family services. Do you see a benefit, or I guess it's do you see that community courts are working for these young people? Because I've went to the Red Hook, there's many community courts in Brooklyn. Staten Island wants to also have a community court, a mental health court. And if you can talk about how this is impacted.
I've had mixed experiences with community courts. I mostly have worked at the Harlem court over the course of my career. They're a better idea, and I think we can improve the model. Now, I had a child who was in the Harlem Community Court who actually was detained because she was still smoking marijuana, and the judge had ordered her not to. And those courts weren't even equipped to, they only met once a week, and the statute says that if you're detained, your proceedings have to move much faster than that, and they weren't equipped to handle everything. So there's a limitation sometimes with what they can handle. But I do appreciate the models where children are the adjudicants. They decide what the punishment should be, whether you've done something wrong. I think that sort of accountability works better for teenagers. And it's something more like a restorative justice model is ideally what we want to implement more often for crimes involving victims, with robberies and such. Having a child and a victim who are both willing to participate, for the child to understand the harm they've caused to someone, and then to try to restore that victim to some sense of wholeness that first helps them better empathize, better learn, and then better correct their behavior. And children really need quick adjudications. There's just a lot of research about how the younger a person is, the more timely the response has to be to their bad act. So when court cases stretch out for 6, 8, 9 months after the alleged incident, the child psychologically is just more and more removed, so the consequences don't feel as related to the bad action. So a community court that works quickly could help in many cases.
Thank you so much. Do you feel that, I mean, the council here, we fund community-based organizations for much of this. Do you feel that the community-based organizations are actually meeting the needs of these young people who are criminally justice involved at the time that they need them? And if not, how could we make that better? So if you're in a youth build program or My Sister's Keeper or My Brother's Keeper, are we matching these organizations locally to any of the issues that you see in family court and probation?
I could say for the children I'm meeting, no, right? Now, I'm not meeting the children who may have met with a mentor and didn't get arrested because of that connection, because I'm working through the court system. So I want to at least say that I'm meeting a certain select population of children who have gotten in trouble. One area of funding I think the city has done really well are the anti-gun violence programs. The Credible Messenger programs have been really important for our clients. The clients who get involved with gun violence and gun possession, those programs, led by people who have been involved in the criminal justice system, have a natural rapport with our clients that's honestly, as a middle-class South Asian man, I don't have the same natural rapport. I grew up in Flushing in New Jersey. I don't have the same background as a lot of my clients who came from East Harlem or Jamaica, Queens. So I would say more funding for Credible Messenger programs, and what that also does is it creates more funding in the community. And so everything that can continue pouring money into the communities that have been underserved, I think reap exponential benefits and help allow the kids connect with people they are more familiar with.
Thank you. So what kind of alternatives to detention and alternative to placement programs are available in family court, and have there been more options since Raise the Age, and what kind of services do these ATIs offer?
So I'll separate. So alternatives to detention, there's usually 2 in every family courthouse. There's one that's with a nonprofit, and the other one is run through probation, the intensive case management, so ICM we call it, and the other one is, there's one Cases in Manhattan, there's another one, Quest in Queens. Actually, they changed their name, I'm forgetting their new name. Those services, what they do is they provide curfew monitoring, and then they will offer some after-school programs where children can get help with some homework, et cetera. They do usually have mental health people on staff, but it's temporary, and so it's while the case is alive, and so my clients sometimes do, but often do not connect with those folks as well as they could, because it's a court-ordered service. And so the most important thing for them is just to do it so that they don't get in trouble with the judge. Alternatives to placement are a different boat. There's the largest one is run by ACS, called the Juvenile Justice Initiative, JJI, and they offer family functional therapy or multi-systemic therapy, both evidence-based models that involve caregivers and the child to help them, because if a child's gonna have success, their parent has to be ready to help them continue, because a teenager doesn't stop being a teenager once the case is over. And so a lot of it is really helping the parent guide the child and respond to the child as they continue making mistakes, because teenagers make mistakes. And so those are the models I find the most productive, but probation also has a few as well, Echoes and AIM, which either help with vocational internship or help with mentoring. So those have not increased since Raise the Age. We have had the same services available pre and post Raise the Age.
Thank you so much, and we'll connect after this and dig a little deeper into that. Thank you, Chair Brewer.
Thank you very much. We've been joined by Councilmember Williams, and we have questions from Councilmember Osei and Joseph. Councilmember Osei.
Thank you, chairs, and thank you to you both for testifying. Thank you for your service, your honor. I do have a question for you, Mr. Kandari. The first question is related to a question that Chair Hanks asked in regards to the community courts. You said that there are some things that are working for the community courts. You've seen some issues within the community courts. I wanted to hear from you how they could be improved. Hearing that they are a good model to start with, how could we help the city on expanding what's working to improve those community courts?
I think one is I would send more children there. I think not enough of our cases go to community courts. Too many of them are cycle through the family court system. So I would love to, the default to start with a community court system for a first arrest. Just send it to community court. I'd be curious what the results would be. And I would always, as I said previously, a restorative justice model where children have to circle up. They have their own supports with them. I think what's really important is children need to have support whenever they're brought into these systems. If they're brought in isolated by themselves, who's going to help them understand what's going on, and who's going to help them follow up with what they have to do to correct what they've done? And so the restorative model really brings in your people to help you then better understand the harm you've done. So I think maybe expanding them more to not just having more availability, smaller, maybe school-oriented community courts, like a district model. I think if we could expand them, they shouldn't be that expensive to staff. So I would think about that. And then we have to do a study to see what works and what doesn't work, because I'm a big fan of research.
What stood out to me in your testimony was when you spoke about how some of these ACS caseworkers seem to work as an arm of the government, and share negative facts or negative things about some of the young people that they're representing. I know that there are, some ideas in terms of how the council could allocate funds to, various nonprofits that assist in this type of work, but we certainly have more control when it comes to reforming and changing some of the ways that in which agencies operate. So I would love to hear from you what you specifically think would need to change within ACS and how they operate, how caseworkers operate, whether it's through legislation, whether it's through advocacy coming from the council.
That's a great question, and I have to think a little bit more to give you. In terms of a legislative fix, I'm not sure right now off the top of my head. What I can tell you right now is training to understand how powerful a caseworker's words are in a court proceeding, and how quickly telling a judge that, oh, he doesn't ever come back, or he just runs away constantly, that judge is so much more likely to detain that child. And so where a parent, I mean, so many parents are like, he stays out all night, and I'm worried about his friends. But they go into court and say, Judge, I love my son, I want to take him home, because they know the most important thing is to keep their child in the community. A caseworker's goal is to keep a child in the community. It should not be to just rat a kid out. And it feels like often they're just frustrated, because those are the children who are often in court, the children who are frustrating, the children who are hard to reach, right? But that's their job. Your job is to dig deep and provide the most services for the children who are the hardest to connect with. I am a lawyer. Those children are frustrating sometimes. They don't want to talk to me. I have to dig deeper. I have to show more patience because they're going through more. The child that has their two parents, this is their first arrest, and everything's going to be hunky-dory, I don't have to work as hard for them. So I challenge everyone to learn more about the impact of their information, to limit how much they're sharing in court, and to understand the consequences of these cases on these children. So I would really focus on training for ACS.
And that's more cases than not in which you're seeing ACS workers or case workers operating like they don't care about the kids or sharing negative.
And so I don't want to speak to whether they care or not. What I can say is they come into court and they have a negative impact very often. Mm-hmm. A lot of times I prefer when nobody shows up, mm-hmm. because then I know that I can just get them to transport and just get them out. When somebody shows up, I worry so much about what they're going to say. I don't have that fear when I have a parent. I feel much better when a parent shows up. Mm-hmm. So ideally, we keep the kids home.
Okay, good to know on that training aspect. The last question that I have is about the alternative to incarceration programs, the very few that do exist. What is working in some of those programs, and how can we expand on what's working with those programs through the power of the city?
So when I was talking about the JJI program, Juvenile Justice Initiative, they use those two evidence-based models, family functional therapy and multisystemic therapy. Those therapeutic models are great, and if parents are when they're willing to engage, those are the ones where they learn the most, and the child and them can connect better. So what I want is those services to be available prior to a case without any sort of ACS involvement. Just can we fund more FFT and MST for families through the community? Can you get it easily? Because sometimes when I tell a parent, the easiest way to do it is to file a PINS petition, and you can get it very quickly, but that shouldn't be the only way to get these services.
And just to clarify, FFT is?
Family functional therapy, sorry.
Family functioning?
Functional therapy.
Functional therapy, and MST is?
Multisystemic therapy.
Okay, thank you. Thank you, Chair.
Sorry for getting into the jargon, my bad.
Councilmember Joseph.
Thank you. Good one.
Yeah.
Thank you so much. Good morning, thank you. My question is, how can agencies work better, all agencies? Because, for example, as education chair, I got this case was brought to my attention. There was a student who was just as involved. He hasn't been in school in 2 years. So you think the conversation between agencies should be happening, and it wasn't happening. He was just as involved. What can we do to make sure that agencies are talking to each other when a justice involved student come into play?
So I think the connection to their school and prioritize, everybody should be focusing on school, right? That's what I do as a lawyer and my social worker. We immediately address what's your school placement, how do you like it, and what are your actual service needs? Because many of our children have individualized educational plans, they have special educational needs. Those are almost never met. It's rare when I'm like, oh, the IEP is being met. And so what I think we need to be doing is treating these children as students and prioritizing their educations. And so every agency needs to be focusing on school, be willing to put the child in a new school. The DOE is a mind-numbing bureaucracy. It is a really hard thing to navigate. I've been doing this for 17 years and I'm going gray faster than I want to because the DOE just doesn't work with us as well as we can. But if we have multiple agencies all pushing their muscles together to get these children into alternative schools, schools that are more focused on getting these children jobs. A lot of children who don't get through 8th grade are likely to drop out. We have Restart Academies, those are great, but a lot of children in 9th grade who don't get their credit are also likely to drop out, but they're willing to do something for money. A lot of my clients are looking for jobs. I have a client who hasn't gone to school right now for 2 years, but every day he's outside on a table selling hats and shirts because he's trying to support himself. And so those are the children who I think we're failing, is children who are hungry for vocational training, for something that's going to turn them into a money-earning adult. That's what we can help, much more than we are right now.
So hopefully the agencies are hearing, so where they should be talking. He was out of school for 2 years, and no one, that never raised a red flag, and that bothered me, that it came to my desk, justice involved, 2 years, never stepped a foot in school, no one had a placement for him. That's unacceptable.
The other part with a lot of these children who don't go to school is if they're in ACS custody, they'll leave, and then they're AWOL, and we don't have a responsibility to plan while they're AWOL. But they're AWOL because they're in the children's center or at a congregate care facility where they're not feeling supported, so they're going to family or friends. And so this chicken and an egg situation is where I'm like, they're not going to plan until he's back in the facility. He's not back in the facility because they're not serving him. So maybe we should find a place where he can be served.
Thank you so much. Thank you, chairs.
It's been going by Councilmember Stevens. Are there no other questions? We will thank you both very much, and we will take a 5-minute break, and then we will hear from the administration. And thank you both very, very much.
Thank you.
Thank you very much.
Thank you. Hi, Jeff. Hi. I'd love to talk further sometime. I would love to. I'd love to. Sorry, I went a little hard on you, but no. We got a lot of work to do. I appreciate it. Yes, please.
Trying to do journey mapping
Okay.
and how young people go through this journey and where the stopgaps. Done this work.
Thank you so much. Nice to meet you.
Would the administration please come to the podium?
We will now hear testimony from the administration. Before we begin, I will administer the affirmation. Panelists, please raise your right hand. And if anyone is here from the administration who is not yet testifying but will be, can you please also raise your hand so that I may administer the affirmation to you as well? Thank you. Do you affirm to tell the truth, the whole truth, and nothing but the truth before this committee and to respond honestly to council member questions? Thank you. You may begin when ready.
Good morning. I'm Jess Danhauser, the Commissioner of the Administration for Children's Services. Thank you, Deputy Speaker Ayala, Chair Brewer, Chair Hanks, and members of the General Welfare, Oversight Investigations, and Public Safety for holding today's hearing on the operational challenges of the Family Court. I'm pleased to be joined by Alan Sputz, the Deputy Commissioner for Family Court Legal Services, along with my colleagues from the Law Department, the Department of Probation, and the Department of Citywide Administrative Services. As you know, all of our agencies, along with many of our legal services and provider agency colleagues, along with judges and the Office of Court Administration staff, play important roles in the family court. I want to take a moment to thank all of our colleagues, as well as the hardworking, compassionate, and committed attorneys and support staff from FCLS for all that they do each and every day on behalf of children and families. The New York City Family Court is comprised of 5 family courts, 1 in each borough, and is divided into 4 specialties: custody, visitation, and family offense cases, child support, juvenile delinquency, and child protection. ACS is the New York City agency responsible for protecting and promoting the safety and well-being of New York City's families by providing child protection, prevention, foster care, juvenile justice, child care, and other community supports. ACS regularly appears in family court on child welfare and juvenile justice and some juvenile justice matters, and our testimony today will focus on that work. The attorneys of Family Court Legal Services are responsible for representing ACS in child neglect and abuse cases, permanency hearings, voluntary placement proceedings, destitute minor proceedings, other child welfare-related proceedings, and some post-dispositional juvenile justice proceedings in the New York City family courts. FCLS attorneys work collaboratively with child protective specialists from the Division of Child Protection, foster care and preventive agency case planners, ACS's Division of Youth and Family Justice, attorneys for parents and children, the Department of Probation, the Law Department, and other stakeholders to further the agency's mission on behalf of children, youth, and families. Attorneys provide legal representation and consultation to CPS and foster care agency staff and provide training for attorneys and social work staff on family court practice. There are currently 164 attorneys and managers in FCLS. We have not seen increased attorney caseloads because, as we'll discuss more later, our court filings continue to decrease each year. FCLS attorneys are critical frontline staff, and ACS has had hiring authority to hire new attorneys throughout most of the pandemic. We are making progress in 2023. Rather than just focusing on hiring classes of attorneys to start together, usually soon after a bar exam, we're also hiring attorneys on an ongoing basis. 2 new attorneys recently started, 4 more are being processed to start in the coming weeks, and we are continuing to make offers to strong candidates. We're also recruiting for our fall 2023 class. As Deputy Speaker noted, we anticipate that this class will have 45 attorneys, and currently the class is over half full, with 24 new lawyers have already accepted offers. To help us with recruitment, we recently contracted with Simplicity, a program law schools use nationwide to advertise job opportunities, which has helped us make offers to very strong candidates for the fall class. In addition, we are continuing to participate in law school and career events, and retention and attrition are returning to more typical levels. ACS has an in-house training unit of 4 highly experienced attorneys who provide training for our new ACS attorneys, as well as legal training for CPS, provider agency staff, and more experienced attorneys. New FCLS attorneys receive 5 weeks of training, which includes courtroom observation and mock trials in our simulation center, as well as guest speakers representing various perspectives, such as parent advocates and prevention providers. After spending some time in the offices, first-year attorneys receive a more advanced training on important topics such as the Interstate Compact and the placement of children, destitute minors, kinship guardianship, immigration, educational issues, and persons in need of supervision. Throughout the year, all FCLS attorneys are required to participate in half-day virtual trainings on topics essential to the work, such as the Family First Prevention Services Act, LGBTQAI+ issues in family court, and the foster care reentry process for older youth. When FCLS attorneys are promoted to team leader, they take a 3-part training to help build their coach and supervisory skills. Training extends beyond legal skills to professional development. FCLS began a partnership with Franklin Covey in 2019 to help develop supervisory management and team building skills for our FCLS managers, as well as our mid-level supervisors and frontline staff. The FCLS attorneys receive close supervision in and out of court during their first year of practice, with an experienced attorney appearing in court with them and reviewing their written legal work. Supervisors continue to provide guidance, particularly on complex cases and when making critical decisions, such as whether to file a new case or whether a child can safely return home. When someone suspects that a child is being abused or maltreated, they call the New York Statewide Central Register, and if the state accepts the report, ACS is required to respond. Our CPS then assess the safety of the children and do so 24 hours a day, 7 days a week, including throughout the pandemic. When needed, CPS seek to work to put in place services or supports to help keep children safe. We only file a case in family court when we believe that court intervention is necessary to protect the safety of the child. Last year, we filed cases in court on fewer than 7% of the child protection cases we conducted. As the chart below indicates, both the number of child welfare filings, referred to as in Article 10, and the percentage of child protection cases that resulted in a filing have continued to decrease each year. This is true despite the fact that the number of reports dropped dramatically in 2020 and started to come back up in 21 and 22. This first chart shows you that there's been a 53% reduction in Article 10 child welfare filings since 2017. This past year, we filed in less than 7% of child protective cases. This reduction in filing applies both to the number of removals, placements into foster care, and to the number of foster care supervision cases. I'll point out in this next chart that the number of removals, remand cases, has dropped 35% from just over 2,000 in 2017 to about 1,300 in 2022. We are seeing numbers move in the right direction. The number of families experiencing emergency removal is also down, from 981 in 2019 to 789 last year. From 2019 to 22, there's been a 46% decrease in the number of cases filed for court-ordered supervision, with most of the current COS filings reflecting children living with non-respondent parents and supervision, and sometimes orders of protection regarding the respondent parent. In addition, the number of COS cases active at the beginning of the year, meaning the number of families we're supervising, declined over 50% from 2019 to 2023, with 7,759 open at the start of 2019 to 3,754 at the start of 2023. We've also seen a continued decline in the number of children in foster care and are now at an all-time low of fewer than 7,000 children in foster care. I'd also like to add to my testimony that on Saturday, we had a record low over the past years of 22 children who were long stayers at the Children's Center of over 10 days. We are working very hard to drive that population down. While there was a slowdown in cases moving through the court process at the height of the pandemic and the family court's decision to focus on emergency proceedings, we are now seeing our child protection and foster care cases moving more quickly through the family court process. A look at both ACS and family court data show that with regard to child protection cases, the court is now disposing more cases annually than the number filed. While adoptions and kin gap slowed during the pandemic, as you can see, the numbers of children exiting to adoption and kin gap are up from 2,000, despite the number of total children in foster care continuing to decline. We have a ways to go here, but we're encouraged by the trajectory of these numbers. While there are more steps that can be taken to move cases more quickly and efficiently throughout the family court process, we are seeing the data move in the right direction. We are thankful that the state increased the statutory number of family court judges in New York City by 6 this past year, which certainly helps to process cases more efficiently. In addition, we believe that the ability to hold some court conferences and court hearings virtually or hybrid has helped to move cases. Finally, ACS, including CPS and our foster care providers, have started a pilot of reviewing cases both early in the case at 90 days and 120 days, and later in the case to see if there are ways to progress the cases that we can propose to other legal stakeholders in the court. While there are some proceedings that should typically be held with all litigants in person, and ACS encourages parents to appear in court in person when we're first filing a new case, we greatly appreciate the family courts maintaining the flexibility of virtual and hybrid proceedings so as to best meet the needs of all participants. For some participants, it is much easier to participate remotely, and the remote option can actually increase access to family court and meaningful participation. Examples include working parents, youth in college, litigants living out of state, and witnesses who cannot spend the full day in court. For ACS caseworkers and our provider agency staff, remote appearance enable them to continue doing much of their work with children, youth, and families on the day of a court appearance, as they just need to log on at the scheduled time. With in-person appearances, staff often need to spend much of the day traveling to and from family court and waiting for their court appearance. One benefit of remote proceedings is that when they are scheduled, there are clear start times and end times for each appearance. The court and parties were largely able to maintain these certain time certains, which make the work we do more efficient, as it has eliminated much of the waiting for appearances that occurs with in-person hearings. As we build a system that includes this flexibility, we need to take additional steps to ensure that remote court appearances best address the needs of clients in a manner that is equitable. While the digital divide and some families struggling with reliable Wi-Fi, we must ensure that family members are able to participate in remote proceedings. In addition to locations in courthouses and attorney offices, we believe this requires creativity to develop locations in the communities where litigants live. One option to explore is a space in local libraries that could provide a computer, reliable Wi-Fi, and privacy. Another option would be to leverage the many community-based organizations throughout the city. We know that the best way to intervene positively in the lives of young people is to engage with the whole family and do so as far upstream as possible, as we heard in the earlier testimony. In New York City, ACS's Family Assessment Program is a diversion program available to families up to age 18 to help avoid involvement in the juvenile justice or child welfare systems by providing therapeutic services grounded in a child welfare framework. FAP is located in or near the 5 family courts to more easily facilitate a referral to PINS. Diversion services so that a petition in family court need not be filed. In addition, families can voluntarily seek out FAP services. FAP supports families in addressing challenging teen behaviors such as missing school, substance use, running away from home, and or those related to mental illness. To minimize court involvement while providing resources to address the presenting concerns, families in New York City must first participate in FAP services before a PINS petition can be filed. FAP serves approximately 2,000 to 3,500 families each year, about 2,600 in 2022, and has been effective at reducing the number of children placed in foster care through a PINS petition to about 15 children annually. FAP providers offer evidence-based models such as FFT, BSFT, and multi-systemic therapy, along with respite care and the MAP mentoring and advocacy program, which now, as of this month, includes Fair Futures coaches. While ACS is not serving as the attorney for most juvenile justice cases in family court, we do play an important role in these matters. As you know, ACS operates the 2 secure detention facilities, where 98% of the youth have pending cases in Supreme Court. 9% of young people in secure detention have cases pending in both Supreme and family court, while only 2% of youth in secure detention have pending cases in only family court. ACS contracts for non-secure detention, where the majority of youth who are ordered to be detained by family court judges reside pending the disposition of those cases. Our typical census is about 40 to 50 youth. ACS also contracts for close to home, the placement system where youth ordered by family court judges to be in placement at disposition are sentenced to reside and where they receive services and supports to help them return to the community. That census is also about 50 youth. ACS and our contracted providers play an important role in transporting youth in detention or close to home to their court appearance. Youth placed in close to home are technically in foster care placements. Thus, for these youth who are post-disposition on their juvenile delinquency matter, ACS attorneys appear in court for any permanency hearing, extension of placement, family first, or revocation matter. Finally, ACS also contracts for some of the services available to youth with juvenile delinquent cases. ACS and MOCJ are in the process of collaboratively transitioning the contracts for alternative detention programs from MOCJ to ACS. This will be effective July 1st. ACS issued the RFP for the ATD programs and recently announced recommended awards for cases in Manhattan and the Bronx, the Justice Innovation Center in Queens and Staten Island, and Good Shepherd Services in Brooklyn. An important new component of the model will include court liaisons. The provider agencies will have staff in the delinquency court parts available to help connect youth to the ATD program and provide status reports to the judges. ACS also administers the Juvenile Justice Initiative, which serves youth adjudicated as juvenile delinquents who are under probation supervision as an alternative to placement. Specifically, JGI provides intensive services to youth in their homes rather than through a placement in a custodial setting. JGI helps parents develop skills to support their children, enforce limits, and steer them towards positive peers and activities. There are additional services available and provided to court-involved youth, which our colleagues here today will share more information about. I want to conclude where I started, thanking all of the ACS staff and our colleagues from other city agencies, the courts, our providers, and all of the legal organizations for all the work they do each and every day. As you can see from my testimony, this collaboration and commitment is essential for meeting the needs of New York City's children, youth, and families. Thank you.
Thank you. Good morning. My name is Ruth Schillingford, and I am the Chief Assistant Corporation Counsel for Criminal Justice of the New York City Law Department. I am joined by Jennifer Gilroy Ruiz, who is the Chief of our Family Court Division. I also bring greetings on behalf of the Corporation Counsel, the Honorable Sylvia Hines-Radix. Thank you, Deputy Speaker Ayala, Chair Brewer, Chair Hanks, and members of the General Welfare, Oversight and Investigations, and Public Safety Committees for holding this hearing. We appreciate this opportunity to discuss the dual roles regarding juvenile delinquency and child support matters that the hard-working members of our Family Court Division undertake on behalf of the children, families, and communities of New York City every day and night in 30 locations across New York City. It is important to note that in resolving our juvenile delinquency cases, we must consider both the needs and best interests of the child, as well as the need for the protection of the community. Rehabilitation is key. The Family Court Division now handles delinquency matters related to youth who are 12 through 17 years of age, or a person over the age of 7 and less than 11 who is charged with a homicide-related case. Once NYPD takes custody of a youth, they have the discretion to determine whether to issue a juvenile report and release the individual or make a formal arrest. If the latter, the youth is then assessed by the Department of Probation to determine whether to adjust the case or refer it to our office. If probation refers the case to us, before we initiate any court proceeding, we determine if it is a valid case. That means investigating the matter through such steps as speaking with the witnesses, viewing body-worn camera or surveillance videos and social media, and applying for search warrants. Unlike other prosecutorial offices, we do not have pre-filing subpoena power. We have submitted legislative requests to change this obstacle. As was the case with the district attorney's offices, who now have tight discovery deadlines, we will need additional resources to meet the demands given the change in the nature of the discovery we now face and are obligated to provide to defense counsel, particularly body-worn camera videos. Now, if the case is not viable, either due to proof or suppression issues, we will decline the matter and dismiss and seal the case. Last year, we declined 2,408 cases. Even when a case is declined, however, that young person can be offered voluntary participation in services through a recent collaboration with the Mayor's Office of Criminal Justice and the United Way. For those cases that remain viable, we assess whether the youth is eligible for our discretionary diversion. Utilizing our diversion coordinators, we consider the risk assessment instrument, including school records, the nature of the case, the youth's role in the purported crime, the youth's history, the position of the person harmed, the needs of the youth as expressed by the family or attorney, including any mental health issues, and any other relevant issues. Last year, approximately 335 cases involved diversion services. This includes cases sent back to probation for pre- and post-filing adjustment services, as well as cases that were sent by our office for pre- and post-filing diversion services. This constitutes approximately 9% of the cases referred. As we reported in the Mayor's Management report, more than 80% of those youth whose cases are diverted do not have another referral 1 year out from the diversion. For your convenience, we have annexed as Addenda A and B lists of providers utilized by the Family Court Division, including the council districts that they serve. I want to share that in addition to diversion specialists for the youth, we utilize victim advocates to assist those affected by our cases through referrals to organizations and provide support to them as they navigate the court process. If a case is not diverted, then we file a petition in court and commence trial preparation as the discovery phase begins. In 2022, we filed 1,183 petitions in family court. The timeline and stages of a case are as follows. Pre-petition detention hearing, which is pre-filing, the initial appearance, which is the arraignment, probable cause hearing, suppression hearing, fact-finding hearing or trial, and disposition, which is equivalent to a sentencing. The timelines are strict and short. If the youth is detained on an A, B, or C felony, the trial must occur within 14 days of the initial appearance. If it is a lower felony or misdemeanor, then 3 days. Even where a youth is not detained, the timeline for the commencement of the trial is 60 days. Last year, 16 and 17-year-old adolescent offenders whose cases are removed from the youth part to family court represented 55% of our referrals. Some of the 3,812 referrals in 2022 included 22 homicide-related cases, 408 weapon cases, 1,033 robberies, 802 assaults, 108 sexual assaults, 149 burglary, and 9 arson cases, representing almost 67% of the total. The most serious cases are handled by our major case unit. And to put these 3,812 referrals in further perspective, they represent a 36% increase from the 2,794 referrals in 2021, and a 10% increase from the 3,454 referrals in 2020. Furthermore, our ratio of felonies to misdemeanor cases has changed from 60-40 in 2017 to 81-19, 81 to 19 in 2022. In addition, we are finding a greater number of youth who have multiple cases, sometimes in multiple boroughs or jurisdictions. Another major part of the work we do, which does not always result in judicial intervention but requires extensive investigation, are the cases handled by our Special Victims Unit. This unit handles all sex offense cases, other cases involving young victims under the age of 9, teen dating violence cases, and any case that originates in one of the 5 child advocacy centers, which include both sex offenses and serious physical abuse cases involving victims primarily under the age of 12. In 2022, attorneys in the SVU conducted 803 interviews involving 452 cases at the CACs. They also handled 965 law enforcement referrals from the state central registry and oversaw commercial sexual exploitation matters. We also handle both teen dating violence cases committed by someone in a romantic or intimate relationship with the survivor and family conflict cases. I'd ask you to make reference to Addenda A and B of service providers for both youth who have committed harm and survivors or those harmed. In 2022, the division saw an increase of over 50% in the referrals of cases involving family members as compared to 2021, from 328 to 505. This increase underscores the necessity of employing a multidisciplinary team approach to addressing the complex factual and legal dynamics that are present for youth and families in crisis. Our Interstate Child Support Unit helps local custodial parents seeking child support representation when the non-custodial parent resides in another state or internationally. The unit also works to support out-of-state or international custodial parents obtain or enforce child support orders from non-custodial parents based in New York. The ICSU has legal support professional staff and attorneys in all 5 borough offices. While the COVID-19 pandemic negatively impacted the number of cases the ICSU has handled in the past 2 years, the numbers are once again on the uptick, with a 67% increase in 2022 of 1,870 referrals as compared to 1,121 in 2021 versus 3,706 incoming cases in 2019. We understand that everything we do in any case that is referred to us will affect not just the youth accused and the complainant victim, but their respective families and, of course, the community. Yet while we tackle attrition, increased and more complex gun and violent felony matters, as well as an increasing number of family conflict cases, we adhere to the paramount goal of rehabilitation while protecting the safety of the community, even though some instances ultimately may result in the placement of a young person. We thank our partners in our effort to work collaboratively as we address these important cases, some of whom are here today from probation and ACS. Thank you very much for the opportunity to speak with you today, and we're happy to take any questions that you may have.
Thank you. I know that we'll have another speaker in a minute. We've been joined by Councilmember Kushner, Juan, and Botcher, and I know you're all doing a great job, but I have to say the advocates are saying good things about Corp Counsel, and I listen very carefully. I know you're all doing great, but just let you know, Corp Counsel.
Thank you.
Go ahead.
Good morning. Good morning, Deputy Speaker Ayala, Chairs Brewer and Hanks, and the members of the Committee on Oversight and Investigation, General Welfare and Public Safety. I'm Juanita Holmes, Commissioner of the New York City Department of Probation. With me today, I have Deputy Commissioner for Juvenile Operations, Janine Gray. Thank you for the opportunity to testify about this important work of the New York City Department of Probation and Family Court. The New York City Department of Probation mission is to help build stronger and safer communities by working with and supervising people on probation, fostering positive change in their decision-making and behavior through research-based practices, while expanding opportunities for them to move out of the criminal and juvenile justice systems through meaningful education, employment, and behavioral health services, family engagement, and civic participation. Working closely with our partners, probation plays a critical role in supporting and guiding the court and various stakeholders in determining the most appropriate decisions and recommendations on both juvenile and adult matters, including visitation, custody, and child support. Our functions at various juvenile delinquency system points include intake, diversion adjustment, investigation, and community supervision. When working with our youth, we strive to promote their well-being and resiliency by guiding them to make positive behavioral changes and sustainable connections to positive community supports. The arrest of a child or teenager should be viewed as a crossroads moment, an opportunity for redirection as needed on an individual basis that balances both accountability and opportunity. In 2022, the Department of Probation processed over 5,700 intakes and over 2,300 adjustments by diverting cases that can be better resolved through an out-of-court accountability process. Adjustments can turn an arrest into a learning experience by addressing the choices and behaviors that led to the arrest swiftly, restoratively, and in a one-size-fits-one manner through an individually appropriate response and plan. This is important for the youth and their families and allows the rest of the family court system to focus time and resources on the remaining cases. For those cases where a young person is adjudicated by a family court judge and placed on community supervision, probation officers partner with the young person's family, caregivers, credible messengers, police officers, mental health providers, and other partners to effectively engage, hold accountable, and provide opportunities for the youth in the community, with the goal of getting them to move out of the justice system. We also operate a continuum of alternative to placement programs in partnership with community-based and nonprofit providers for the cases needing the highest level of supervision, and in which the youth would have otherwise been adjudicated to out-of-home placement. Last year, DOP supervised 1,070 youth across the city with a 92% completion rate. After a judge makes a finding in a case, probation typically performs a court-ordered investigation. Investigations, POs work with all of the relevant partners of the young person and their case to provide the court with a full picture, as this will help render the most appropriate decisions and balances public safety and what is best for the young person. Our court liaison officers play a crucial role in ensuring we can have a positive relationship with the judges, law department, and other parties so that cases can run smoothly. In 2022, Department of Probation prepared 671 investigation and reports and delivered those reports to the court on an on-time rate of 95%. Throughout all of our functions, we continue to build upon and leverage what works for young people in the justice system. Credible messengers, formerly justice-involved people themselves, can be impactful as mentors for our young people and are embedded throughout our work. We also utilize parent coaches whose own children went through the juvenile justice system to serve as guides for our families who are unfamiliar with navigating this new system. Lastly, we try to think out of the box to anticipate any needs, which is why we are in the process of implementing a partnership with local organizations to provide services to young people who otherwise would have none while their case is referred. All of these measures help to ensure we have a robust variety of age-appropriate services and opportunities so that our young people can develop their unique passions and begin to thrive. As you know, probation is just one of the many parts in family court. Our partnership and collaborative relationships span the continuum and include the Administration for Children's Services, the Corporation Counsel, Law Department, and the Office of Court Administration, just to name a few. All are integral to ensuring the best possible outcomes for young people, victims, their families, and their communities. Thank you for the opportunity to testify today, and I am pleased to answer any questions you may have.
Thank you. Next is. Then we're going to have Senator. Okay. So we'll start with questions. I just want to do some overall, and then we may be joined in a few minutes by Senator Hoylman Siegel, who is head of Judiciary and who wants to participate. Is there anybody here from DCAS also? All right, because I do have a DCAS question, just so you know. So my first question, I'll just do some overall questions, and then I'll call on my co-chairs and then others. So I just want to hear about the buildings. Bronx, Staten Island, staff went, judges complain. It's terrible. And obviously, there is a feeling, you heard from Justice O'Shea, that the other courthouses are in better shape. So how are we going to fix up the courthouses so that they are able to be worked in, number one? Number two, I personally saw terrible Manhattan-based technology. What's the status with the technology? What's Matt Frazier doing about it? What are we going to do about that? That's facilities. Just generally, how are we going to deal with the Department of Education? You heard from earlier, I didn't hear, but maybe I missed it, a lot of coordination with DOE. Your caseload may go down, but the students are not in school. So how do you work well with the Department of Education, making schools a focus, as Councilmember Joseph made in her comments? I'm also concerned something specifically about the overtime challenges. We heard that from the judges themselves in the courthouse. Other courts get OT, these staff do not. That means 5 o'clock, I'm out of here, case continues, that's a problem. And then I know that the mayor has appointed some judges. What's the status with more appointments? Maybe I need to ask the appointment office, but obviously, the judges need to be there on a timely basis. How are you dealing with, as Justice O'Shea said, sticking in civil court who don't know anything, don't want to be there in the first place, and better to have judges who want to be there? So those are my overall questions, starting with DCAS. Your courts are a mess.
Good afternoon, Chair Brewer. Thank you for the question. So we work closely with OCA to try and address issues that arise in the court, everything from cleanliness to capital projects. We have recently changed the structure at DCAS in order to try and get to problems in all of the courthouses, in family court included. I know there's a number of capital projects that are underway for many of the family court centers. And in terms of the day-to-day issues that arise, cleanliness, custodial staff, maintenance and repairs, we're trying to triage those issues differently to address them more effectively.
Whose buildings are they?
Well, they're all managed by DCAS.
Yes,
even
that's
if
my
they are-
understanding. So you have, the staff here has pictures of massive leaks. What's the status of any money capital money to fix them up?
So I can give you,
With all due respect, you didn't mention it.
I can give you the capital projects, some of the capital projects and the current funding now, but I think the ones that you're talking about, the leaks in particular, so the pictures that were in that report were from Bronx Courthouse, and we've worked closely with DEP to address the larger infrastructure issues that are leading to that, but we have installed stopgap measures which have, as far as we know right now, have remedied the leaks for the time being. So, for instance, over the weekend, when there was about 2 inches of rain, we did not suffer from leaks. We're putting gate valves, we have inspected the pipes, and that seems to be a fix for now while we work on the larger pictures. But for instance, in Queens Family Court, there is a capital project right now to replace the roof because there's leaks in Queens. There's a very large-scale project for Richmond Terrace to address the issues with that building. If you want more specifics,
I don't need all the specifics now. I just want to be sure that after this hearing, we do get a specific list of exactly what's going to be done to address the facilities that belong to the city of New York.
Absolutely.
Okay. And just quickly on the task force, what happened to the Williams Report task force? Does it still exist? ACS, anybody? There was a task force that the Williams Report indicated existed on family court. Does that no longer exist? Did it ever exist?
We're not aware, Chair. We'll look into it, though.
Okay. And then Department of Education, how do we coordinate with DOE? These are general questions, and my colleagues will have specifics, and I may later, but.
Sure, I can take a first stab at that, Chair. So the DOE is actually the #1 referral source to our family assessment program, which is serving a little over 2,600 children a year. So they reach out to us if they're having concerns, if they need additional support relates to behavior. They also have opened up a dedicated office for children in foster care specifically. And so we're doing a lot of work with them around transportation issues, making sure young people have what they need. I also want to make sure everyone's aware that we have invested over $30 million in coaches for young people. Some of the dynamic that was described earlier, we take very seriously. Part of that is because case planners had too much on their plate, including all of the youth development work. We have now brought on a cadre of coaches who are responsible for that work to make sure young people have their educational needs met, to make sure that young people have vocational opportunities. We've brought that work into the juvenile justice arena, so it'll be part of our FAP program as well. It'll also be part of our close to home program, and we're working over time to bring it into our detention. So the work with DOE is very, very intimate, and we're trying to accelerate it.
Okay. And then we'll have the state senator in just a minute, but the other of overtime, who can address the lack of overtime in this court compared to other courts for the court personnel?
As needed, we will fund overtime for our attorneys. We absolutely know that they've been working extraordinarily hard. as I said earlier, while caseloads haven't risen, their job is extremely challenging, and we're bringing on reinforcements through the hiring process, but there's not a issue with overtime at ACS.
So I think the court personnel will be state then. In other words, so the state needs to have an overtime change, not the city.
That's right.
We're going to hear now very quickly from State Senator Harleman Siegel, who is head of Judiciary. Senator, go ahead. Go ahead, Brad.
Thank you, Chair. I just unmuted myself. Thank you very much. Thank you, Chair Brewer, for the opportunity to testify about the dire situation facing our family courts and litigants. And I really appreciate you and your committee and the entire City Council's interest in this topic. As the chair of the Senate Judiciary Committee, addressing the crisis of family court is one of our top priorities. Our work has been informed by the Jay Johnson Report on Racial Inequalities in the Court System, the Franklin H. Williams Judicial Commission's report earlier this year on New York City Family Court, which you mentioned, and the reporting of a number of journalists, including Melissa Russo at NBC4, and the report of the New York City Bar Association on the impact of COVID-19 on family courts. I encourage the members of the committee to review these materials if you haven't already. It's very enlightening and heart-wrenching, I would add. Last year, we in the state legislature were able to secure 4 additional family court judges for New York City. And this year, we hope to add as many as a dozen more, which experts like the Williams Commission have said is necessary to begin to fix the system. These new judges will address delays by providing caseload relief to existing judges and reduce the system's reliance on judges elected to civil court and temporarily assigned to family court, where they may have less interest and less familiarity with the law. More judges are necessary, but not sufficient. Family court litigants need competent counsel. And while many litigants qualify for a free assigned counsel, the low rate of compensation for those attorneys has led to an exodus of experienced attorneys and an inability to recruit new talent. My colleagues and I are at work in Albany as we speak to finally remedy this injustice in this year's budget. The governor, Senate, and Assembly all agree that compensation rates for 18B assigned counsel needs to be significantly increased, though there are differences of opinion on details like the exact rate, caps on compensation for individual cases, and whether there should be a uniform statewide rate. I've urged my colleagues that we need to be as close as possible to the compensation rates provided to attorneys under federal assigned counsel programs with a uniform statewide rate, and that the increase in compensation must be paid for by the state. I'm also fighting for an increase to the budget of the Office of Indigent Legal Services Parental Representation Program, which requires funding of $28 million to uphold our constitutional duty to provide counsel for parents, and a $15 million increase to institutional providers of attorneys for children. These investments in counsel and judges will go a long way toward immediately addressing the crisis in family court, but the state has much more work to do long-term to truly do justice to family court litigants. We must continue to increase resources for the Commission on Judicial Conduct to address behavior from judges that dehumanize litigants, provide mandatory annual anti-bias training for judges and court personnel, collect additional data and create more avenues for observation and feedback, and increase other non-judicial resources for the family court, along with other procedural fixes to address delays. I'm encouraged that during our confirmation hearing for new Chief Judge Rowan Wilson, he shared our view that family court should be a top priority for his tenure. Chief Judge Wilson said that he would be an on-the-ground, detail-oriented chief judge when it comes to family court. I'm confident that his administration will implement the internal court changes necessary to improve family court. While many of family court's issues can be addressed at the state level, we do need the city's assistance with certain issues. First, while we can create new family court seats, we cannot ensure they are filled, and we cannot control whether the judges appointed reflect the diversity of New York City. The mayor, as you know, is responsible for appointing family court judges, and just last month, he appointed 6 new diverse candidates, for which we are grateful. We still have a long way to go, though, and his In its report earlier this year, the Williams Commission found that while family court is largely utilized by people of color, over 60% of New York City family court judges are white. I urge the mayor to continue to quickly fill any vacancies and to continue to diversify the bench. Second, the New York City Department of Citywide Administrative Services owns the family court buildings and is responsible for maintaining the courthouses. These buildings need major repairs to their foundations, ceilings, and plumbing system. DCAS also needs to ensure better regulation of maintenance to keep the courthouses in a state of good repair. In the longer term, extensive renovations or new buildings will be necessary. The current conditions are demoralizing to court employees and court users, giving the impression that family court is a lesser court whose litigants and witnesses are somehow not as worthy as their counterparts in other courts. Any condition that demeans our court users is simply unacceptable. Thank you again for providing me the opportunity to testify and bringing attention to the myriad of issues in family court. For too long, family court has been allowed to deteriorate in the shadows, and I hope that your advocacy today, this hearing, is one more major step to bring those problems to light and fix them. All New Yorkers deserve to be treated with dignity by our court system, and none of us should rest, council member, until that's the case. Thank you so much.
Thank you very much. And now we'll hear from Council Member Diana Ayala, Chair.
Could you try again?
Good afternoon, everyone. You know, I'm a little bit, I'm frustrated, not with anyone here, but rather with this system. It doesn't work for me. I don't understand how it works for families and for young people within our care. And I think that if we took the time to invest as many resources as you have all mentioned today, inside of their own communities before they even became justice involved, that we wouldn't even be here. I have community centers that look like places that you would not want your children to come into, and this is where most of our kids spend, all of their free time. And there are no services. I mean, you can play basketball, but there's no one there. There's no social service provider. There's no wraparound service. There's barely an adult in the room to coordinate anything and to offer family support. I know that the family enrichment centers are opening. I'm really excited about that, but I wonder if some of that can maybe transfer out into the local community by virtue of our local community centers. There's a huge need there. There's a big void in services, and I say that as a Black and brown, individual who grew up in public housing. My mother was on welfare. I am one of 8 children. And we struggled, and nobody came to rescue us, right? And my mother did the best that she could, and I did the best that I could, and some of us made it out, and some of us didn't make it out. Because some of us just were not born with or developed the skill set to thrive in such a difficult environment, And quite frankly, I'm always surprised that I got out. And sometimes I still feel like I'm in there, I still feel like I'm in there because I still see a lot of the remnants of that in my own community, in the community that I now represent. And that's why I think I'm so passionate, and many of my colleagues are so passionate about these issues, because it's not about criticizing the administration, because I think that we all can agree. I've met with many of you, and I genuinely believe that you have the best interests of our young people at heart. I think that where we are lacking and where we can be doing better is really in the coordination of resources, because, if we have a shortage there's a workforce issue throughout the entire city. We have a shortage of lawyers in every single category: housing lawyers, criminal defense. That can't be disputed. So if we were to increase the budget for ACS to hire up more attorneys to represent families, you still wouldn't be addressing the lack of attorneys and staffing personnel at the courthouses that are also slowing down cases. So I don't know how we resolve anything and move cases along and help families in and out of the system as quickly as possible without having to further traumatize them, unless all systems are working together. I don't see that. I really don't. And I know that you have good intentions, but until that level of coordination happens, we're screwed. We're screwed, and so are the families that are coming before all of us. In regards to the, well, for DCAS, I will say that I do have the Harlem Justice Center in my district, and it's been closed for quite a number of years throughout the pandemic and pre-pandemic. You know, I can't tell you how many times I was on the phone just talking about leaks in the roof and how that was impacting workspace. And, you know, I believe that that is part of the reason why not all of the building has been able to reopen. And quite frankly, I wonder, is there like a list of properties that are under the purview of DCAS? And is there like, do you report annually on how many properties and what the level of capital need is per property, and how much money is being allocated yearly to address those issues? Because this goes beyond the court systems.
Sure. I mean, we can get you absolutely the list of the buildings that are under our oversight and the capital projects that are ongoing, the projects that have capital requests, and a schedule and a timeline to look at when those are addressed. As far as the Harlem Center, and I can look into that and get back to you with the timeline on that one as well. Not all of the buildings have current active projects that would address the scope that you're talking about, but I think it's exactly what we need to do, is work with the partners and see how to prioritize and what needs to go first. We do that with OCA, we do that with all our agency partners, but we always welcome any conversation to go a little bit further and see how we can prioritize what is on the minds and needs of the people that are in those courthouses.
Yeah, I mean, if you look at the photos, I don't know how many of you had an opportunity to look at these, but I mean, they're pretty dire. I mean, you have no ceiling in one building. I mean, the entire ceiling is gone. You know, massive leaks throughout the buildings. I mean, that doesn't look too healthy, right? And people are, these are actual workspaces where, you know, people are expected to work.
Right, I can tell you, I mean, for those pictures, the roof and the leaks have been repaired, and we have fixed most of those, but you're correct in that these are old buildings. There's a constant level of need for capital improvements and repairs.
Go ahead. Councilmember?
Go ahead.
Who took the pictures? No,
I believe people were there on Friday, so I don't know how fixed they were. Just, I mean, maybe you did it on Saturday.
Yeah, and I might not be thinking of the pictures, if they're the pictures from the report or there are pictures from Richmond Terrace.
Well, yeah, and maybe if you can, if there's a way to maybe post in the building so that people know capital work is coming, this is when it's happening, because, you know, we're troubleshooting, and in reality, people should know what the status of the upgrades is, right? Whether we're talking about 20 years from now.
Sure.
They should know, right, that this is not happening as quickly as they think that it is.
Right, we can do that.
But in all seriousness, the city has to put in money and invest money in their own buildings. You know, we are like our worst, you know, nightmare. Like, we're the worst landlords in the entire city of New York. And I don't understand that. We find money to fund all type of stuff, yet our buildings, you know, are not places where I would want to hang out. I would never work in those. Okay, so I said that. I just want to make sure that I get through these. So in terms of the cases that are referred out of the family court division, do we know what that number is? How many youngsters? And I'm horrified to see the age of 7 listed on this, but I believe it's through 17 versus the cases that get sent over to the other, which court is it that represents the 17 and 18-year-olds?
I'm sorry.
I'm just trying to figure out how many of the cases that were seen last year, of what the percentage is, right? Because there's two different courts, right? There's the family court division, and then you age out or are sent to another, is it criminal court?
So
So since the enacting of Raise the Age, it actually happens the other way. So all cases that come into family court involve youth between the ages now of 12 to 17. That changed last year. It had been 7 to 17. In the family court, initial jurisdiction is for youth 12 to 15 for all cases. 16 and 17-year-olds start in family court for all misdemeanor cases. 16 and 17-year-olds arrested for felony cases start in the youth part of the Supreme Court in each county. And so and then they can be retained in the youth part or removed to the family court.
Okay. And for those that are diverted, that are sent back home, is there any supportive services that is being offered to the family? Because, I mean, oftentimes we're sending kids back home to an environment where there's somebody waiting to shoot them. Just want to put that out there.
So when the youth are released by the court, they can be released to an alternative to detention program, which had been mentioned. If they're released and they're not yet before the court, there are no services currently in place for those youth.
There are no services?
No, not currently, no.
Can I just add to that? So the ATD, the Alternative Detention Programs, will be coming to ACS as of July 1st. So we just awarded contracts to Good Shepherd, to the Justice Innovation Center, and to Cases. So that would be an alternative to detention that the judge would order. There are voluntary services through FAP, so our Family Assessment Program. So any family that wants to reach out to our FAP office in any of the boroughs can do that. Last year we served 2,600 children in that, and we have room. They include family therapies. We're adding the Fair Futures program, so there's a youth development coaching component. So those services are available. They are, of course, voluntary, so it's up to the family whether to take them and that young person whether to take them.
Yeah, I feel like once the kid is sent home or to some sort of diversion program, there has to be some level of social service provided to the family. I had a family at Wagner Houses 2 summers ago that, the child was involved in a shooting, and literally the whole family packed up and left overnight. They had to leave, and they were homeless because they had nowhere else to go. You can't just transfer out of public housing, and especially overnight when somebody's looking for you, right? And that's a real thing. That's a real thing.
Chair, can I just add to that? Also in probation, we have the adjustment cases. Those that don't qualify for the adjustment cases and are deferred to move on to Corp Counsel, we had a gap that the individuals in that particular group weren't receiving services, weren't referred to services. Now we've filled that gap. We identified it through a statute in Family Court 309.1, and as a result of such, all of those individuals that were waiting for their case to be heard will now be provided with recommended services.
That's great. That's great. There was a question that was asked before to Mr. Kandari, but I wanted to ask Commissioner Danhauser this. For children that are in ACS custody who are charged with juvenile delinquency, what kind of support do they receive from the foster care court, and who appears with them? Does anyone appear to take them home? What information do they provide in support of the child?
Absolutely, and part of we've been taking a close look at our crossover youth model. Thankfully, there are fewer young people who are crossing over from the child welfare system to the juvenile justice system, but when it happens, we have a cross-divisional discussion led by our Deputy Commissioner Nancy Ginsburg and Deputy Commissioner Ina Mendez. We bring providers to the table and we look at the best services available, either through the child welfare or juvenile justice system. As I said earlier, I think part of the dynamic that was being experienced, and one that we never want to happen, is that the case planners were being asked to take on so much of that role. Now that we have coaches in place that are specifically designed for youth development, I expect that experience to improve dramatically. Our expectation is that in our funding is that the coaches can stay in that young person's life no matter where they go. So in the worst case scenario where they're in secure detention, they can stay in their life. and our whole portfolio of services is open to those young people. We're also looking at making sure that young people who have juvenile justice experience and then need to come into the child welfare system because there aren't the appropriate family supports, that they have everything that they need and the appropriate transition to housing and other types of supportive services.
Okay, I have two more questions and then I'm done, sorry. How has the raise the age affected juvenile delinquency cases in family courts? And are the cases taking longer?
Thank you for that question. We are now obviously dealing with 16 and 17-year-olds, and so we've had an increase with respect to the types of cases that we're getting. We're getting more robberies, we're getting more firearm cases, we're getting more assault cases, more attempted homicides, and we have right now some homicides. So that is the difference in terms of the types of cases that we're getting. We're getting much more serious cases.
So the cases are more serious in nature, but is that creating further delays in the court system?
Well, I think part of there's a mixture of things with respect to delays, right? The nature of discovery that we're required to provide. You have body-worn cameras. I don't know if any of you have ever viewed body-worn cameras, but usually when the officer, it's not one officer who goes to an incident, and you're not worth your salt unless you are reviewing those body-worn cameras with respect to a case. And so to the extent that some of the delays may be occasioned by that, and I believe that those things are important to have and to review, and so there may be adjournments that are necessary. I can't speak to the reasons that the defense may need in order to proceed with their cases. From our end, what we try to do is work as quickly as possible to get whatever discovery we need to get to counsel in order to move the cases along.
And Commissioner, can you tell me how many cases are children left in placement longer than necessary because the cases are being pushed out so far?
So I don't have an exact number for you, Chair, but we can work on it.
But is that happening? Because that concerns me that we're keeping kids in foster care and ACS care longer than necessary because cases keep getting pushed, down the road.
It's a major focus for us as well, both our family permanency, working with our foster care providers. We have recently changed the contracts with our foster care providers to pay them based on a program size, which for the first time really gets away from paying them for the number of times a child is sleeping in their bed. And so it really sort of focused on permanency. We have targets with each of our providers, and we're providing a lot of support to them. As you know, the providers have been struggling with staffing, and so our new contracts enhance investments in staffing. What I can say is it's not where we want it to be, but the population of the number of children who are in care for over 24 months is down 7% over the last year. So we're starting to see some promising trends. The population that's in care between a year and two is down 5%. And the number of children that went home in that first year in 2025 was just under a third, which was up from about a quarter.
What are the numbers? I know you say 7%, 5%, but what, because that could be 7% of anything. Just so we have some numbers. I know it's in your.
That's a fair point. Chair, give me one moment to get the
I can make
exact
a
numbers for
7%
you.
of anything.
Hold on, I'll go back to my testimony to make sure I have it. It's not 7% of a small number. So just to give you the numbers, for all discharges, we're seeing that the number of non-permanency, which means kids aging out of care, come down from 654 in 2019 to 542. We've seen in 2019, there were about 4,000 children discharged from foster care. It dipped to 2,556 in 2020, and it's been back up over 3,000 in 21 and 22. So what we're seeing, there's also a fewer kids coming in, so some of the population is smaller on the front end, but a higher percentage of that population is going home.
Okay.
It is, let me just be clear, we still feel like we have a long way to go to make sure that every child has permanency in a timely way. There are also very important due process considerations for parents that we take seriously in New York. So that also contributes to the time frame to make sure that parents have an appropriate amount of time to rectify any of the situation. But we are always looking at, we started that work to have a review at the 90 or 120 day mark to see, are we working with fathers sufficiently?
My concern is not so much ACS. My concern is that in cases where ACS would recommend that the child be, turned over to the biological, family, and now you're going to court, and now the court, that court, date is adjourned because, of a shortage of staff or for whatever reason, and now not calendared for another 5 months, and then we go back, and then there's another incident, and now this kid is in foster care for an additional 9 months, longer than, recommended by even ACS. That's the part of it that, I'm trying to get to.
All of the recommendations that have been laid out today, more family court judges, making sure that technology is right, are all really important, because that any delay is too long. I do think, as I said in my testimony, that while we're encouraging parents to be there, especially at a filing, when virtual visits allow for more time certains, historically, it's been very hard to get a time certain, so our staff would sit in court. I've been visiting the courthouses. They are very quiet. And most of it is because most of the cases are virtual. We want families to have due process and to be there in that first visit, but at the same time, we're starting to see things move in the right trajectory because we're showing up at that link and the judges are ready and everyone's ready, and so we're able to move forward at a greater rate. We are not where we need to be, and some of the recommendations that have been laid out today are important to make sure we get there.
Well, I'm going to propose to Councilmember Brewer that we go this summer and hang out in family court and see for ourselves.
I would,
absolutely. How many cases, because that really scares, it scares me to think. I mean, it's a traumatizing experience. I was a former foster parent, and I know, and I have children, and I know that, I would be traumatized, but, for the kids, like being away from mom, being away from dad, in cases where, they could easily go back and we can support parents. I'm not talking about, more severe cases. Then it just seems criminal to me that we're, allowing that to happen. And with that, I will shut up because Councilmember Brewer is going to kill me.
I will not. I want to thank Councilmember Velasquez-Iñigo for being here. I'm going to quickly call on Councilmember Stevens because I know you have a challenging schedule, and then we're going to hear from the great chair of Public Safety. Go ahead, Councilmember Stevens.
Thank you very much, and I will be very brief. Chair Ayala already kind of alluded to some of the questions that I have, is just around like, what does the coordination look like amongst all city agencies that work with young people? Because, we have DOE who's over there teaching our young people. We have DYCD who does all this work. We have all these things, and to me, a lot of it just seems like no one is talking and everyone is doing their own thing. So my question is like real specific around like, do you guys have shared goals? What do your monthly meetings look like? How are you making sure that the services that you're providing on all the programs, Chair Ayala already said, like, right, like you have the centers that's opening up. Will they be in community centers? What does the outreach look like? Because it does not make sense to me that all these agencies were investing all these monies and there's really no coordination of services. And so, if we had, more preventative services, a lot of these things wouldn't need to get here. So can you talk about what does the collaboration between all these offices look like? How are you meeting? Are there shared documents? What does those meetings look like? Are they monthly? Are they annually? What do they look like? And how is all of this information being translated about the work that you're doing in ACS, DOE, DYCD, all of the systems that anytime a child is being touched, how are you cross-collaborating this information?
Thank you for that, Councilmember. I'll start and see if my colleagues would like to add to that. I think in addition to meetings that the mayor convenes and the first deputy mayor around the gun violence task force and deputy mayors with their portfolios convening on a very regular basis, we are doing a lot of work, and it really goes back to the heart of what we're trying to accomplish here. We would like to reduce the number of unnecessary reports coming to ACS so that we can take resources and invest them upstream in community, consistent with the mayor's vision. So we are meeting on a very regular basis with the Department of Education.
So could you talk about like who's at those meetings? Because the
Sure.
other issue for me is a lot of people at the top talk, but a lot of folks who are actually doing the direct service and actually doing the work never meet, don't know each other, never seen each other, and all those things are separate. And so it's happy that the commissioners might be meeting, but to me, that's not the people doing the work. So how is that really being translated?
Sure. So we are working to drive that down. I think that's a very important point. In addition to large meetings at the commissioner level, we are doing local meetings. So with specific schools, our community partnership teams are meeting with specific schools to make sure they understand pathways to support for families, to make sure that they understand the difference between when you call the SCR, when you call FAP, when you call one of our preventive agencies. So we're trying to do that work on the ground level.
You guys do work with schools. What does it look like with the after-school program staffing? Because let's be clear, and I'm gonna be clear about this. Even in schools, sometimes I get a little janky because I've been in programs where the school will be like, nah, you can wait till you go to after school, and they'll call ACS because we're not doing it. So what does that look like even in the DYCD programs? How are you guys meeting with them? Because yes, great, you're meeting with the school staff, but then we have this whole host of other people who are working with young people who often are left out of the conversation.
Yeah, and I'm not trying to suggest it's perfect, but some of the efforts, both DYCD actually runs some of the programming within our juvenile justice programming, so we're doing work with Commissioner Howard, who's coming out to visit that. We do not see the after-school programs reporting at a very high level, but I'll take a deeper look at that. But that will be part of our full outreach to make sure that we're clear with folks about who to contact in what type of situation, so that we're only getting the type of reports that are necessary and that we're getting families the quickest access to services.
I hear you, but I think that that's part of the problem, right? Like, you shouldn't just be seeing reports. People should be meeting, right? Like, that's part of the problem. Like, I've worked in this system for 20 years and no one talks. And so, it's a lot of these things where you're talking about all these services that you're providing. And if we had them in, Chair Ayala said, in the community center before, some of the things would be preventative. Or we know a lot of our young people are court involved. So what does that look like to have those services already available there? So it's always this disconnect of how we all working together, and reports are nice, but that's just paper. And let's be clear, when you're running a program, you don't have time to read a report because you're actually on the ground doing the work. And so we really need to think about what does this really look like, and how, or whether it's having borough meetings and having, school providers there, DYCD providers, and all those folks there to have conversations about what this looked like, because these are the same kids. All of them are in all the same programs, right? And so we're referring them out and doing all these things. I mean, we have these WACOs, don't get me started on that. Everybody knows I hate that. But we have those folks over there working with the kids. They're going to probation, they're working with kids and they're getting services, they're in ACS involved, all of these things, but there's no coordination about how we're actually gonna work together and having the people who are doing the work working together.
So, Chair, you are speaking my language, right? And, I've been here 6 weeks in probation. These are the discussions that I have, I know, with my staff. I have DOE on my schedule today. I have DYC coming up with Commissioner Harris. I always speak about coordination because it creates structure. There are so many programs throughout the city, and we're doing our best. I speak with ACS. I know what programs they have, but from my previous employer, right? So I think about exactly what you're saying. Anyone touching a child should be speaking to one another because it is the same households. And I knew that in 2015 when I was chief of domestic violence. So we're going to do better and get better at coordinating. And like you said, people speaking with people. It is so essential because we are in a lot of the same homes. So if I walk into a home, and when I say I am representing DOP, Department of Probation, and I see something that may have a little flagrant to possible neglect, I should be able to see, right, with technology in New York City, if, by going in with a certain level of access, if there is a ACS case in that particular house. So I'm not generating another one. I'm just adding additional information based on my visit. Here's what I've seen. And that's a huge technology undertaking. Could be, I don't know, but I know that I've been speaking to this, that giving us all access to DOE. I supervise a 13-year-old. I shouldn't have to make a school visit to see if that child is going to school. I should be able to go into a system with a certain level of access to DOE and see that my child has been attending school. And so all of these things would create more efficiency, therefore allow us to be more effective, therefore cut down on certain man hours where sometimes you have to do the legwork and go and take care of it. So there are a number of things that have been identified with speaking with the agencies, and we are moving forward to get better in that particular area. But you are speaking my language. I agree.
Yeah, I mean, like I said, it's just very frustrating because, like I said, I worked here for 20 years, and I was one of the people who it's just so hard. And like you said, it should be. It's 2023. There's technology. It's available. It's about, is that what we really want to do, and figuring out what that looks like. But we have to move there because the reality is our kids are hurting, right? They are suffering because we are not communicating and getting that information together.
I'm going to call on our co-chair. That's okay.
Oh, I'm done.
Okay. The great Public Safety Chair, Camilla Hanks.
Thank you, Chair Brewer, and I definitely need to echo the sentiments of my colleagues, Deputy Speaker Ayala and Councilmember Stevens, all of us having done this work. You know, if you look at your testimonies and you read them, you're like, this is perfect. But it just doesn't necessarily play out that way on the ground. And I think that these hearings are extremely important to make sure that we're looking at that journey map, to seeing that every single touch is relevant and we're getting young people and folks with the services they need. But my first question is to DCAS. I'm also looking at this photograph of Richmond County Family Court. And, you know, the scaffolding has been up for 13 years. The steps have been in disrepair for 10 years, and it's completely out of service since August of 2022. So my question is, at what point will this be completed? What is the timeline and the funding stream that we're looking at here?
So I'm going to have to get back to you with the funding and the timeline. I know for the steps, that is a DCAS project that we were working on ourselves, and we lost significant staff that was working on them. We have recently hired. That should be rolling again. As far as the scaffolding and the entirety of the project, which is being undertaken by DASNY, but we are constantly working with DASNY in terms of when that project is going to kick off and be complete. So currently, we know DASNY is hiring the bridging contractor. It's a partial design build, so it is rolling. And let me just look at one of my colleagues to see what the funding is. It funded? Okay, we'll have to get back to you on the funding and the budget. I know DASNY on their site says it's over $100 million project, but I'm not sure where they are in the funding. But the scaffolding stays up. And the shedding stays up until compliance with the facade laws, former local law 11, to make sure that nothing is falling off the building to injure anyone.
13 years?
So a lot of these projects, I know scaffolding and shedding is a big issue in the city right now where the work hasn't been done. So the larger capital project has to be finished, and I'm going to ask our chief engineer too, if I'm saying that correctly, that the larger project of the construction and the addition to 100 Richmond must be finished before that scaffolding can be taken down.
Yeah, but just we're looking at a timeline that's been up for 13 years and has been in disrepair for 10 years. And I think that, my colleagues, especially the bookend of boroughs, have been neglected. And, 5 years is understandable, but when you're talking about over a decade of disrepair, it's completely unacceptable.
Yeah.
And so I definitely would like to know when this project is supposed to be completed. But
Sure,
thank
we'll
you.
get you a timeline for that.
So my next question is for Ms. Shillingford. So we testified that NYPD, once NYPD takes custody of a youth, they have discretion to determine whether to issue a juvenile report and release an individual or make a formal arrest. If the latter, the youth is then assessed by the Department of Probation to determine whether to adjust the case or refer it out to our office. So I think my first question is, can you explain who makes the determination where a case should be heard and how this might change the penalty or someone found guilty? We just wanted to know what is the process to that. Hope I asked the question properly.
I'm sorry, can you repeat the question?
So our understanding is that the acts, considered crimes should be alleged to be committed by children between 7 and 18 years old are generally heard in family court. But for some more serious or violent acts, these cases could be heard in the youth part or the Supreme Court. Can you explain who makes the determination where a case should be heard and how this might change the penalty for someone found guilty?
Yes, thank you for that question. So the law actually indicates that anybody who is 16 or 17 and charged with a felony begins in the adult Supreme Court in the youth part. That is different than other jurisdictions where there's something called a waiver up. That didn't happen in New York. So when we have somebody who is arrested and the police department has made a determination to arrest that youth, if they are 16 or 17, the case goes directly to the district attorney's office, who then determines whether to file. If it's a felony and they're under 16, or if it's a misdemeanor for anyone, the case goes directly to the Department of Probation, who determines whether or not adjustment is appropriate, and they can speak much. And I would ask Commissioner Holmes if he'd like to add to that.
So that's correct, yes. They come to the Department of Probation, and at that point, whether it's, I believe it's through intake at that point, and they fill out what's called an INR, investigation report. That's when it's determined whether or not this individual qualifies to go to adjustment, whether that would be more of a benefit, what's taken in consideration, support systems, whether they've been rearrested, the victim's statement, naturally, family support, several other variables are taken in consideration to determine whether or not a diversion program would be more suitable for the individual than going to pre-filing.
So I think, my bigger question is, what happens between all of that time frame? So when we talk about journey mapping, a young person who comes into the judicial system at a younger age and arrest is not made, what does that look like through all these processes, and what happens to this young person?
Well, through our process, the initial report has to be done, especially if they're in placement, within 10 days. When you're talking about family court, probation has 4 to 6 weeks. Sounds long to me, but it's 4 to 6 weeks in order to process a particular, what's called a investigation report, the INR. Once that's done, it's sent to Corp Counsel if they're not recommended for a diversion program. But during that time frame, which I explained earlier, these children weren't receiving or recommended any services or resources. So now that gap is being filled with the Family Court Statute 309.1, where we can recommend resources, services. Naturally, they would have to volunteer on a voluntary basis, but at least it's going to be recommended. Determine, why is this child possibly robbing to begin with? Are they hungry? Do they need food? What services do you need? And what can we provide? And where can they attain those particular services and resources? That's the process. Once it's referred to Corp Counsel, if they're not going to qualify for diversion or adjustment, then that's the process that kicks into Corp Counsel. Now they have to take into consideration all the different variables. Everything's discovery now, which you know. And as a result of such, like what was mentioned earlier with body-worn cameras, evidence, which I can defer to Corp Counsel to speak about that point.
Just one question. What happens to this person when you're working all this out?
So what happens to the young person when we're filling out the
Or are
investigation? They're usually home.
Okay.
Right, and if they're in placement, that's when the time span of 10 days kicks in. Because they're in placement, we want to expedite this decision.
Okay, thank you.
So I would just note also that with respect to the statute, Section 309, which was passed by the state last year, it's an unfunded mandate, okay? So there's a recognition that there's something that needs to be done with respect to these young people in between, and yet no funding for that. So that's one of the things that we think would also be quite helpful in terms of filling that gap. With respect to once the cases come to us, we make the determination right at the beginning whether or not it's a viable case. If it's not a viable case, a young person should not be considered for any sort of diversion because the case is not valid. The case should be dismissed and sealed. So we do that preliminary, that threshold evaluation. Thereafter, we exercise our discretionary authority to see whether or not the case is eligible for our discretionary diversion. And that's where we utilize our diversion coordinators and make those determinations and utilize the various programs that we have listed in our addenda and utilize those programs. Ultimately, there comes a point where if diversion is not an option, that we have to make a determination whether or not to file. And again, even with that, we still have to conduct our investigation with respect to, we continue to investigate the case and then move forward with the case.
How long does that generally take? There's a lot of if-thens in there.
A lot depends on whether or not someone is in, if someone has been detained, in which case everything moves much more quickly. And from our end, if you're talking about making a determination on a case where someone is not in, we have our own internal thresholds with respect to when a case should move. And we've recently put into place some policies with respect to if a case is over 45 days, then we need to have an explanation with respect to what's going on with the case and move the case forward. So we're cognizant of the fact that whenever any case comes before us, essentially two people's lives are on hold, and we need to move it as quickly as we can.
Well, firstly, I appreciate the appendix. That was extremely helpful. I also wanted to ask you, you said there are unfunded mandates. If there were funding available, or if you were to advocate for funding in what I'm looking at as gaps,
Sure.
where would that funding be? What would it look like?
I'll turn it over to.
So, as Commissioner Holmes indicated, there is a period of time where we're investigating the case. And just to be clear, Councilwoman, we're different than the adult system because we cannot file absent sworn testimony. So we don't send the case directly to court. We must have that sworn testimony from the witnesses, and that is something that takes longer to get. However, from the time that the Department of Probation refers the case until we file the case, that's the gap that the Commissioner identified. That's the gap that 309 was enacted to address. However, when it was enacted, there were no services. So if the youth is being adjusted by the Department of Probation, they have a plethora of services. If the case goes into the court and we file a case, if the youth is being released home, that's where the ATD programs that Commissioner Danhauser just spoke of come into play. So that's the specific gap between referral and filing or declination. An additional gap that was a serious gap was that, as Judge Schillingford has said, if a case cannot be proven, we cannot mandate somebody to services. However, based upon a collaboration with MOCJ and the United Way, there are now voluntary services available to youth whose cases are declined. And so we're able to make a referral of any case that's declined to those services. They've rolled out slowly. They're in, I believe, 4 of the boroughs. I think it's still coming on in 1, and I'd have to tell you, I don't remember which. However, those are voluntary, so we don't get a report back. Nothing can happen to someone who doesn't do those services. But when Mr. Kandahari spoke, he spoke of family functional therapy. That's what they are. And so that's an opportunity now that had not been in place for a very, very long time.
So there's nothing in place to require someone to be part of a program in that purgatory space, in that space that's kind of in between? Because I think that that's really, as far as what, what this committee looks at, when the preventative and the intervention, we do not understand how all this process works, and what is that spot in which we can intervene and provide services that are not mandated. I mean, maybe we need to have a further conversation in how we can do with the Raise the Age legislation, along with discovery and all the other things that we're talking about. These young people are slipping through the cracks.
That's right.
They're committing crimes. Often it's being escalated. And even in Staten Island, the shootings that have happened have been 14 and 15-year-olds, primarily 14 and 15-year-olds. And if we do not have a mechanism in which we can capture, or, and I guess capture is not that word, but to intervene at that space when you do have them, to make sure that we can mandate some sort of, a program for them, so we're capturing, at least in providing services. But my last question, my last 2 questions is, for the law department, how's the staffing? Are you able to, do you need more experienced attorneys for the more serious cases? What does that look like?
Okay, so as, with respect to our situation, as is the case with other stakeholders, the division has experienced significant attrition. So since 2020, during COVID and thereafter, we lost approximately 111 attorneys and 79 support professional staff. That obviously, when people leave, we have caseloads, they have cases, and the cases go to those who are remaining, right? And so it has been and continues to be difficult with respect to managing our cases. However, we have been in touch with OMB with respect to increasing our entry class from what we had in the previous years. As you recall, during the prior administration, there was a hiring freeze, and our numbers were very low from there in terms of entry classes. But again, with respect to, I think, any organization, the question is experienced attorneys, being able to compete for those experienced attorneys, and we're hiring because, I'm the last person in terms of our division as far as hiring, and so we're hiring, but it is difficult, and we have to be able to compete, and I'm hopeful that we'll be able to do that.
Are you hybrid?
Are we hybrid? We are in the same position as any other agency and look forward to the resolution.
I know the answer. But you guys got to push harder for hybrid. We're in court, everybody's hybrid except for you. Thank you.
Thank you, appreciate that.
Thank you, Chair Brewer. Thank you to everyone who testified. I would love to continue this conversation offline. Thank you so much for your answers.
Thank you.
Councilmember Joseph, and then Councilmember Kirshner.
Thank you again, chairs. I have a question. I have a couple of questions for ACS. As the education chair, when I got here, there was no office to deal with students in foster care, so we established this office here.
Thank you.
We still have issues. I met with 30 foster care agencies on Friday, and the majority of the complaint I'm getting is around transportation. And here's how it sounds. So my 2 boys came from foster care. So when my 6-year-old needed to go to school, they offered us a MetroCard. That can't happen. 6-year-olds should not be able to get on a train to navigate. Remember, they're being pulled away from their mom and dad already, or whatever setting they were in. That's already traumatizing. And to offer them a MetroCard at 6 years old is unacceptable. So when they come into care, I want to see what does a transportation plan look like between you and DOE, and how the agencies are getting reimbursed on a timely fashion, and what's the policy around transportation.
Thank you, Councilmember. I agree with you, and thank you for your advocacy in establishing that very important office. This is a big focus of ours. We immediately work with the DOE to put in requests for transportation. We also are working with providers. I think the biggest challenge, we are reimbursing for transportation in that early stage. The biggest challenge for the providers is looking at when there needs to be someone who's accompanying the young person. Many of our foster parents work, and they're not able to accompany the young person to and from school. And so we are absolutely doing that reimbursement. We are looking at a number of models for trying to support their accompanying the young person to the school. We look very regularly at our school attendance data, which is starting to trend better in the right direction. This is an ongoing challenge, but we are focused on trying to meet it.
Summer Rising is coming, it's around the corner. When a child enters care, Summer Rising starts July 5th, let's say someone enters care is July 10th. What does that transportation look like for that child that's coming into that system?
For Summer Rising specifically, I'll have to get back to you.
Well, Summer Rising is occurring, and one of the things they put out was priorities for students in temporary housing and students in foster care. So how do we get the students from point A to point B to their programming with transportation?
So it would be the same process. We'll reimburse the providers if they go out of pocket for that, absolutely. And we work with the DOE to try to make sure that transportation is in place as quickly as possible. We're also trying to look, right now, we're seeing slightly increasing, we talked earlier about placements of children where they are, slightly increasing placements of children in their home borough, which is obviously key. We obviously also focus deeply on kinship, where over 50% of the children are coming into kin. And we've increased the reimbursement to kin in those early days to make sure that they have some additional funds to care for the child early.
Thank you. Earlier you said the numbers are down. Is it due to COVID that the numbers are down in children coming into care?
It's not due to COVID, but we learned a lot from the pandemic, Councilmember, and we're serious about applying those lessons. So during COVID, the family courts put in an emergency protocol that we could only bring to family court what was emergent, even if it was for supervision. So we are essentially only filing cases where there needs to be either a removal or somebody in the household composition is a danger to that child. So we have looked at that over time. We have not seen increasing rates of serious major injury to children as a result of this. And so we have made the decision to adopt that as policy. And we're currently working on drafting that policy while the court order is still in place. So it is not related to the pandemic because reports have come up in one way, but it's certainly a lesson learned from it.
Thank you. And earlier you said, how long does it take a child from removal to return to parent? If not return to parent, how long does that take?
I'll get you the exact numbers on the average length of stay. This past year, about a third of children returned home within that first year. And then depending on the pathway from foster care, whether that's kinship guardianship, which we've been using a lot more of, I'm sure you're familiar, but just for others, that This is subsidized guardianship for family members who have been foster parents for over 6 months. So I can get you those numbers as a
That
follow-up.
would be nice, because I'm familiar with cases. Our case took about 5 years for us to finally adopt the 2 boys. And I don't think anyone should go through that traumatic experience, especially if they're opening their homes and the need is there. It's not like the need is not there. The need is there.
Yeah, absolutely.
Thank you, chairs.
Councilmember Christian, and then Councilmember Williams.
Thank you so much, Chairs Brewer, Hanks, and Ayala, for today's hearing. Thank you all for your testimony today, too. Good to see you, Commissioner. I wanted to just take a step back for a second and frame my questions around 2 things. First, I think you're hearing from a lot of colleagues today, too, and emphasizing this point. The child welfare system, in my opinion, is not really about the welfare of the child. There are so many, as I always say, family separation happens in New York City every single day. And I know you're all aware of that, too. And you look at the statistics, over 90% of families that are investigated, prosecuted, removal, but over 90% even just at the investigation stage are overwhelmingly Black and brown families, and especially in low-income communities of color. So we've got a lot of work to do, because if we really are talking about a system that's in the best interest of the child, then the work that needs to be done to really keep families together, I think, needs to be the focus of the system. There are 2 areas I'd like to focus on just for my 2 questions. One is on the court system in particular. I know, and I've said it too as a lawyer that practiced in housing court for many years representing tenants, in the civil side at least, housing court and family court are in bad need of reform. The problem is dire in both courts. The physical photos that we're seeing of how deteriorating the conditions are is just a metaphor of the deteriorating state of justice in the family court system, as well as in the housing court system. And so there's a lot to be done, and my colleagues have raised it in terms of addressing the physical structure, because how that structure looks and how it really opens its so-called doors of justice to families who are coming in affects the kind of treatment they receive in the court system, and for something as emotionally traumatic as family separation and removal happen in these courthouses in such bad repair is shocking. But I also want to focus on, we talked about the repairs before, the actual perspective of the judicial system. Because as I mentioned before, the best interest of the child standard, the way in which things proceed with large caseloads for the judges themselves, and we heard from a former judge before, it doesn't seem to me like the court system is actually focused on keeping families together. Just like I've seen in housing court too, the high caseloads mean that judges are churning through cases. They think that it's a two-sided thing, and the moral value of actually keeping families together is absent from these proceedings. So I'm just curious to know from you all, in your work as agencies, as administration, as Corp Counsel, what efforts are made on a larger level in making sure that our judicial system is reorienting its perspective to be truly about keeping families together, so it doesn't feel like a system that is really focused on these immense racial injustices and ripping apart families.
Thank you, Councilmember. I agree with you. I can't speak to the reframe for the judicial system as a whole, but that reframe that you reference is absolutely underway at ACS. In my testimony, I just want to share with you, we've reduced court filings from 7,600, almost 7,700 in 2017, to just over 3,500, 53% reduction. And we've reduced the number of cases that we're bringing for remand of a child into care from over 2,000 to about 1,300. We're focused on making sure our preventive services work can reach families earlier. And as you and I have discussed, we're also looking at ways in which we can think about family services outside of the construct of child welfare, right? Families have appropriately their stress involved with connection with the child welfare system. We are working hard to reduce that stress, but also thinking more broadly about ways in which families can get services outside of that. One thing I will note is that our CARES process, we are about 18% last month of our cases went down a CARES track, which is a non-investigative track that is more focused on supportive services to families. This is after a report is made. We have a long way to go, but that's some of our focus to make sure that we are representing in court, that we are there in the best interest of that child and that family, and that those interests almost always overlap.
And, you know, as I mentioned, Commissioner, I know that these issues are systemic, and so, you know, I know the work that you're doing, and I would urge you all to continue working with, to the extent that it's happening, but even more so, coalitions like PLAN. I see Joyce McMillan here too, and many others in the room that are advocating every single day on these issues to truly reorient a system that is utterly failing in the families it should be serving. I have one more question, if the chair will permit. My other question on the other side of this goes to the investigation stage when it comes to mandatory reporting and the work being done with your agency and others who want to weigh in as well to actually address many of the serious deficiencies in the mandatory reporting system. As a child, I was the subject of mandatory reporting. My family was investigated by ACS. It gave me a glimpse into what thousands of black and brown families are facing exponentially worse every single day in this system. Recently, when I was walking my child to school, I had to help a mother that was similarly part of a mandatory reporting incident that just happened as well, and she was deeply traumatized. And so on the initial investigative side, where these mandatory reports are being filed, what is your agency doing? What are the agencies gathered here doing to address these serious errors that happen with mandatory reporting? Again, in a system that the statistics are very, very clear of the racial disparities. And I think especially when it's that overwhelming and clear, there's real work to be done on the front level when it comes to investigations.
Thank you, Councilmember. I couldn't agree with you more. It is 6.6 times more likely that a black family will be called in on a report as a white family in New York City. This is nowhere near okay. We are doing a lot of work. The state has reformed its mandated reporter training to be more clear about when a family should be called in for a report versus support. And we're trying to move forward and not only allowing that reframing from the state, where the state central registry decides whether they're taking that report or not, but to do the work on the ground to make sure that our partners at DOE know pathways to support rather than a report, that our shelter providers understand that. We're doing that work with health and hospitals. We're meeting bi-weekly with Joyce and others around narrowing the front door initiatives. This is a major, major investment that we're making. We have not seen the number of reports come down quite yet. We're about 10% below pre-pandemic levels, which is better. But we feel like we have a long way to go, given that very, very sobering statistic.
Thank you. And I would just close by saying, as I started out, if we're really serious about, child welfare and we're really serious about keeping families together, then, Councilmember Stevens made the point before about the conversations happening from the top levels of the agency down to the staff as well. And the same way, too, I would say a lot of the work involves both the working with the advocates on the ground every single day who are on the front lines of these fights, and also really changing the perspective within the court system. And a lot of that is beyond the data, the statistics, but in that deep outreach and work with community organizations, and fundamentally really changing the systemic problem that we face. Thank you.
Councilmember Williams.
Good afternoon. The first set of questions I have is for ACS. And this is around adjourning cases. So does family court judges ever adjourn cases because of ACS staff? So lawyers or caseworkers are unprepared, and do supervisors track when this happens?
I'm certain that it happens. I don't know the exact numbers. I will say that our staff, we've been doing a lot of work on training with them. We've been doing a lot of work with providers and our CPS to make sure that they are prepared for family court. We take very seriously the timelines and making sure that families have due process. We'll look into what we track.
Yeah, I know in your testimony you mentioned that virtual hearings help with caseworkers being able to attend. So just wondering if you are seeing that there is an influx of caseworkers and or lawyers not being able to fulfill their obligations and cases having to be adjourned.
We're not. We're seeing the trends move in the right direction. We were mentioning earlier that the percentage of children who are going home within that first year has gone up last year. Then the populations of children in foster care who are there for a long time is coming down. We still have lots of work to do to make sure that due process is fulfilled in a timely way while making sure that parents have an opportunity to address the situations that led their child coming into care.
Okay, thank you. The next question is also in relations to cases. Why do you think so many cases are filed by ACS and family court take so long to get to the fact-finding hearing? And do you believe that it's the FCLS discovery practices, if that has anything to do with the fact-finding hearing and the timeline around that?
We've recently taken a very close look at our discovery process, as this was raised by our colleagues in the parent advocates, and so we're making sure that we are producing both timely and in full to make sure that all of our information is available to defense counsel. I don't think it's what's driving sort of the primary delays, but happy to sort of hear more from them. We are seeing getting to fact-finding moving a little bit more quickly in this. I really do think that the virtual hearings are helping. And it's really less about the virtual as much for that particular aspect of it, but that it's allowing for time certains to happen more frequently so that folks can rely on when they can come to court. So again, a place where we have a long way to go.
Okay, so outside of just reviewing, is there anything else that you're doing specifically to tackle this issue or investigate this issue further?
I think the most important things are that we continue to be very judicious about what we bring to court in the first place, and make sure that we are not bringing cases to family court that we can resolve with support to families. We're trending very well in that direction, and we'll continue on that. We're also working on hiring and training of FCLS attorneys. We typically went class by class when the bar exams were taken. We've started to hire on a more rolling basis and adjust our training protocols so that we can bring on attorneys throughout the year. So those are a few of the things that we're working on.
Okay, another question about the attorneys assigned to cases having discretion to settle or withdraw cases. So, there are reports that attorneys don't have the proper discretion to essentially dismiss weak cases. So are you aware of their discretion to settle or withdraw cases?
So any attorney, so this is a decision-making process that's a team process between our Division of Child Protection, our Family Court Legal Services, on cases where there is where there's a family removal, child removal. We have supervision in that to make sure that we're making the right determinations. So no single person has discretion. We make a team decision. Often we'll have conversations with parent attorneys to make sure we're doing that. We're also starting to expand on a pilot of review at 90 to 120 days to make sure we've engaged fathers, to make sure that we are looking at potential settlement. We're also looking at the expansion of mediation as a potential way to expedite cases. Sometimes things get sticky in court, and it takes time to either develop the facts or get the disposition. We don't want to wait to that to consider things like mediation.
Okay, I can come back. Are you doing a second round of questions? No, I have more than one more, so I'll just email them or write a letter. No, but it's okay. You want me to go? Okay. I'll just write a letter to the law department and go to Department of Probation. What are the things you're considering in making a determination whether a case should remain in intake or be referred to family court?
Oh, as far as diversion's concerned, adjustments. So I know, keep in mind, I've been here 6 weeks, but I've been reading the risk assessment or the investigation report. I know that whether or not they've had previous crimes are taken into consideration, family support, going to school. The victim statement is taken into consideration. I do have my Deputy Commissioner of Operations for Juvenile here, so if she wants to add to it.
And also, sorry, and if you could ask or answer how long it takes to make that decision.
Okay, so to determine if a kid is eligible for adjustment, it takes 7 days.
Thank you.
As the Commissioner Holmes had said, we take in consideration of all the relevant parties, parent, child, complainant witness, police officer. We also assess how well that young person is doing in the community. Based on that, we determine if the kid is eligible, and then we do a service plan for that kid. It's always one size fits one. And our goal in adjustment is really just to make sure that we can change that behavior so that child doesn't come back. The kid stays open, or the child stays open, and adjustment's about 90 days. But we usually close our cases between 60 days, depending if they successfully just complete some of the things that we have asked them to do. But I just wanted to say also, when we do adjustment, it's not just about the kid, it's also about their family. So we also use the parent coaches that we have that are available to our parents because we want sustainability after they leave us. So it's about to do the whole family, be holistic, with credible messengers are also provided with our young people, but we're just trying to make change, so we do, everyone.
Thank you.
You're very welcome.
Thank you very much. Back to ACS for a question, which is retention. I know you've mentioned here and in general welfare that you are hiring more attorneys, et cetera. I assume you're still under the same lack of hybrid problem that I brought to the mayor's attention for over a year. But in addition, those who are leaving, are you doing exit interviews, number one? And number two, what are you doing to try to retain this professional staff? Because without them, we're going to have even more adjournments.
We are, and absolutely, workload is an issue, so bringing on folks to support our family court attorneys is important. We also see many attorneys leave for other opportunities. We currently...
Where they can go hybrid. Go ahead. Every attorney in New York City knows this.
Yeah, I think one of the most important things is to make sure that their role is understood and valued. I've been spending a lot of time with our Deputy Commissioner Sputz out with our family court legal services attorneys, making sure that they understand the direction of the organization and that they are responded to, that their facility issues are responded to. In our Bronx office, DCAS has done some recent renovations there, that we're making sure that they have what they need as very, very important part of the system.
Okay, so you don't do exit interviews per se to see why are you leaving?
We do. I have the overall exit interview information, which really speaks to other opportunities that they're pursuing, that speaks to some of the job responsibilities. So we are looking across ACS at a simplification effort to make sure that we don't put on unnecessary burden on anybody, that they are focused on their core responsibilities. So those are the couple of things that pop up. I don't know that they're specific to FCLS, but in my conversations with FCLS attorneys, those are the things that they bring up to me.
Okay. Councilmember Williams asked about adjournment, but did you give her, I don't know that you did, or maybe you said you will, how many cases are adjourned because of lack of paperwork, for lack of a better word, from attorneys or caseworkers from ACS? Again, maybe it's shortage, but it does seem to us, I do have a lot of friends who are judges in family court, which is honestly how this all came about. I can't mention their names because they get upset that they will be in trouble. However, that's what's happening. So do you track the adjournments as to why? And if it is staffing, paperwork, et cetera, how do we address this?
We don't track that at ACS as I understand it, but I'm sure the court tracks adjournments, and we can look at what those trends are. I'll be happy to ask Judge Jolly if there's a way for us to get a better understanding of that.
The reason I ask is that's what the judges complain about. They do have a lot of complaints about lack of paperwork, timeliness on ACS. I'm trying to be nice to ACS, but I'm letting you know, big complaint. So that should be tracking. Is that something that would be available that you would take a look at in the near future?
We absolutely will. We do track the permanency hearing reports and when they are filed by the agencies and work with agencies to ensure timely filing of permanency hearing reports, which is a key report, but we'll see if we can get even more granular data.
And language is always an issue. Do you have a language access plan that you are going to be releasing, or is this something that you focus on?
We are focused on it. Our Deputy Commissioner Gendel oversees that work. We have access to translators in all of the city certified languages and make sure that our staff have access to them.
Are you supposed to be releasing a plan on access, language access? Do you know about? She knows everything.
I know.
She knows everything for the last 40 years. She should be in charge.
Okay. We are. The current plan is online.
How did I guess? Anyway, Councilmember Ressler's here also. See, he always leaves when I announce him. Okay. My other question, just on a more general, I think we're all trying to deal with poverty, and obviously, I don't know that this is possible, and after so many years, I should know. But the money that goes into foster care, could it be used to keep families, children with families? Because obviously, that is where the rubber hits the road. I'm a foster care parent, she's a foster care parent, Councilmember Joseph, we've all been foster care parents. The money that could stay in the home could help keep the children in the home, but it goes to foster care. Is that something that could be moved around, or is that never discussed because it cannot be?
I think over the course of the last 20 years, what we've seen is a dramatic reduction in the use of foster care and a dramatic increase in the use of preventive services. Unfortunately, there are separate funding streams for federal purposes, and the Family First Act at the federal level does allow for more money to go into preventive services. But in our conversations with community advocates, parent advocates, and others, they are not looking for an expansion of our preventive services system. They're looking for more direct investments in families. And so I don't think that that's something that, a reduction in foster care can fully fund, but we're in active conversations about how to move that money as far upstream as possible. There are federal and state limitations on that. For example, the 65-35, what should be 65-35, requires in-home family services, requires that there's a risk of foster care stated. We don't think those requirements should be on just good, excellent family services. So we're looking to advocate around that, Chair.
Thank you. I appreciate everyone being here. I will say that we're going to look toward a follow-up letter with some of the questions we didn't have time for today. And secondly, a state, city, formal or informal task force on family court to try to bring together, the state needs to do its part, and also to try to get the city to be as responsive as you possibly can. Thank you so much for your testimony. And next we'll hear from the folks who are coming for the next panel. Thank you very much.
Thank you.
Thank you, Chair. We will now turn to public testimony. We will be limiting public testimony today to 2 minutes each. For in-person panelists, please come up to the table once your name has been called. For virtual panelists, once your name is called, a member of our staff will unmute you, and the Sergeant at Arms will set the timer and give you the go-ahead to begin. Please wait for the Sergeant to announce that you may begin before delivering your testimony. I'm pulling it up. Now I will call our first in-person panel. Ronald Richter, Philip Katz, and Brian Zimmerman.
Go ahead, thank you very much.
Is the microphone working? Okay, so you'll forgive me, I'm a little over 2 minutes. You could feel free to cut me off. I didn't get the 2-minute memo, but I will start and you just tell me where you want me to stop. Okay. Well, first I want to thank you all specifically. I want to thank chairs, Ayala, Brewer, and Hanks for permitting me to speak here. I think we're speaking about something that's really important, and I think it's great that the city is focusing in on this. It's something that's been neglected for far too long. There's no more important work done in our court system than the work done for children and families. For this reason, I'm here to tell you that the family court should be given the highest priority when New York City resources are allocated, and their operations should receive the maximum support that the city can provide. Sadly, experience has shown me that family court is not given the appropriate level in terms of resources or operational assistance. Families are the foundation of the city. As with any structure, if its foundation isn't given priority, then everything built on top of that structure is going to ultimately crumble. Thus, it's imperative that New York City put its foundation, its families, first when making policy and legislative decisions in order to ensure that the city remains safe, strong, and prosperous. Well, let me start with a bit of positive news, because I've heard a lot of things where we have challenges. Our family court administration and the judiciary are, for the most part, hardworking, caring, and qualified people. They truly care about children and families, and they do all they can with the limited resources that they're given to make our family courts places where best interests of children and protections of victims of intimate domestic violence and the rights of parents are given highest priority. And as an attorney who's been a member of the assigned counsel panel in New York City Family Court for over a decade, and as a leader of my family court panel, and as the vice president of the Assigned Counsel Association of the State of New York, I've spent my days, my nights, my weekends dealing with issues regarding children and families and how to navigate the family court. That means I come face to face with many of its operational challenges. In addressing those operational challenges, there's a lot the city can do. Everything the court system and the city does relative to family court proceedings should center around the most important players in the process, and that's the litigants. Families and children need to be assured that the process is fair, efficient.
You need to start to wrap up or summarize.
Okay, so, well, first, my apologies, but first I want to touch on the virtual process. Virtual process is something we learned through COVID can be an invaluable part of the system in the right places. The city should facilitate this and encourage this by creating community centers where there is internet, where there is availability. Number two, with respect to appointing of judges, the mayor's office obviously leads that charge, but more judges are needed. We've heard talk about that. There's a problem with the fact that elected judges end up in family court for 2 years. And in a 2-year period, a case can take longer than that. We need to have family court judges who are dealing with cases that start from the beginning to the end, and that doesn't happen, sadly, in our court. Either that 2-year time frame has to be expanded.
Justice O'Shea mentioned that.
Right. Or something else needs to be done to make sure that we have more judges there. Now, with respect to the assigned counsel, and that's who I represent and where I work, we're a diverse group of individuals. We represent come from many cultures, many ethnic backgrounds, and speak many languages. We're focused on helping families, but our hands are often tied when we try to do this. We're given no benefits for the work that we do. We're required to maintain offices.
Summarize.
This is, I'm summarizing, Chair. I'm doing my best here. So, with respect to the fact that we get no rate increases and we get no assistance, then it makes it hardest for us to help families. They have a constitutional right to counsel that they're not getting to the fullest that they deserve. We're required to make ourselves available for at least once a month, if not more, to do this work, be assigned to cases. I started on this panel over a decade ago, and about 2011, there were about 70 attorneys on my Manhattan panel. By 2020, there were 35.
We're going to have to stop. We have many more witnesses to go, but we'll definitely accept your testimony.
Okay, and I have submitted my testimony. And if I may say one last thing,
Quickly.
The city has a language line account. We have residents that speak over 200 languages. We should have access to that language line account. We've been fighting for that for years, and we've been given lip service. That is something that could speed the process up, would be actually efficient.
Got it. Thank you very much.
Thank you.
Judge Richter.
Can you hear me?
Yes.
Okay. So good afternoon, Chair Brewer, Chair Ayala. Much appreciation to Council Member Williams. Thank you for calling this hearing and inviting me to testify on behalf of the children and families we serve. Do I have more time?
You got 2 minutes.
Took all your time.
Just like everybody else.
I'm Ron Richter, and I do
Just
want to
because
say...
I know you doesn't mean you get more time.
I know. So I do want to thank both chairs who are present for an enduring commitment to the people that the family court serves, and I think that I'll just put out there that a city-state working group of any sort to advance more equity in family court is an amazingly important suggestion because...
I'll make sure you chair it.
Okay. I'm Ron Richter, CEO, Executive Director, JCCA. I have been honored to serve both as the ACS Commissioner and as a judge in Queens Family Court. I've basically spent my career around the court. Although the specific recommendations I'm making do not directly relate to race, the disproportionate involvement of Black and brown families has to be kept in mind every day. Family court hours and availability are designed for court staff, as opposed to the individuals and families who come before the court. Currently, family court hours of operation are posted as 9 to 5, much shorter than civil and criminal courts. This schedule limits the availability of the court to respond to emergencies where delays can cause further harm or burden to families. If a New Yorker needs an order of protection, they should not be forced to wait until court reopens the following day. And as you know, family court issues orders of protection that no other court has jurisdiction to issue, namely where there isn't an arrest and people live together, for example. The schedule reduces the amount of time judges can spend considering the needs of each family that appears before them. I support legislation that increases the hours of the court. We spend a lot of money making sure that applicants in matrimonial matters in Supreme Court can get emergency applications for vacations, for time in the Hamptons, etc. In family court, literally hearings are stopped at 4:30, even if a judge is deciding whether to remove a child. That is abhorrent and represents inequity in our court system. Judges literally have court staff telling them it's 4:30 and they need approval from a supervising judge to go to overtime. That has to change. Family court strongly discourages overtime, as I just explained. 18B salaries have to be increased. Parents deserve the most able counsel. You've heard this before. I just want to say institutional providers have made it even more pronounced how important it is to support 18B lawyers. Finally, I really feel strongly that all of this business about hybrid family court proceedings has to be regulated by the court system, that it is not appropriate for judges to be conducting termination of parental rights fact findings while a parent is using free Wi-Fi at McDonald's. That is unjust and has to change. Other jurisdictions have put together kiosks around their city, including Maricopa County in Arizona, so that parents can fully participate with their lawyer and be treated like human beings. It is extremely disconcerting that I've had a judge ask my agency to host a parent and their lawyer for a termination proceeding when we are in fact the presentment agency. That just reflects desperation on the part of judges. So it is an honor to be here. As you know, chairs, I feel really strongly about this stuff. Family court judges are working very hard, as are the lawyers and the court staff that work with them, but they need a significant investment in strategic ways. So thank you very much.
Thank you both very much. Did you both submit testimony? I know that we have some here, but you will.
I definitely did, so if you don't have it, I'll leave an extra copy if that's
No,
okay.
we'll make sure that we have it. And thank you both very much. These are serious issues, and we're going to take them very seriously. Councilmember Williams, do you have a question? Go ahead.
Yeah, I just wanted to ask, outside of the recommendations you listed in your testimony, are there specific recommendations or additional recommendations you have for how the agencies could work better to improve court proceedings as well? You know, we heard a lot of testimony from ACS and like as former commissioner of ACS and also like a judge, do you have other pointed recommendations?
Yeah, I mean, I agree with Chair Brewer that offering agency staff, ACS staff, limited ability to work remotely sometimes is making it very hard for ACS. I think the reduction in filings is very important, and I think that that should continue. I do think that the Department of Education is not here, and their absence should echo around the room. Kids in foster care desperately need educational supports more than any other kids, maybe homeless kids also. But I was the commissioner a long time ago, and I was a judge a while back, and DOE has persistently been unengaged, I would say, in the effort to educate our kids in care and also our kids on preventive cases. So I think coordination is important, but as everyone is saying, it has to occur on the ground. And I think agencies can be helpful in that, and that might be a worthwhile undertaking to figure out how to institutionalize some of the coordination.
Thank you both very much.
Thank you, Chair Brewer.
Thank you for your testimony. We will now hear from Miriam Mack, Neelad Natarajan, Zainab Akbar, Jennifer Feinberg, and Justine Van Straten Lil.
Whomever would like to begin, go ahead.
Thank you. Good afternoon. My name is Zainab Akbar, and I'm the managing attorney of the Family Defense Practice at Neighborhood Defender Service of Harlem. Thank you to the chairs and the members and the staff of the committees for this opportunity to testify with my colleagues from Bronx Defenders, Brooklyn Defender Services, and Center for Family Representation about the family court system. We collectively represent the agencies who provide public defense in New York City's family courts. We are here to ask the committees to focus not on nameless, faceless standards and goals, but instead on the real impact that the current functioning of the family court and ACS has on your individual constituents, their families, their communities, and the city at large. The current state of affairs in family court is a reflection of the structural racism and classism that underlies this system. And which system am I talking about? As you'll hear from us, our organizations have affirmatively adopted the phrase family policing system or family regulation system to describe what has traditionally been called the child welfare system. And we do that because that reflects the system's prioritization of surveillance, punishment, and control of low-income Black and brown and other marginalized communities rather than genuine assistance to families. I'm here to provide a background and history to our collective and joint testimony. Just like our modern police systems are directly descended from slave patrols, the family policing system's origins are in the separation of enslaved Black children and parents to profit from their labor, and in the government-sponsored separation of indigenous children from their parents, meant to destroy the communities whose land the government was seeking to colonize. Today, as everyone knows, Black and brown children are separated from their parents by ACS and placed in the foster system at rates hugely disproportionate to their presence in the total population of New York City's children. And this is not an accident. Widespread research, including 2 recent internal investigations commissioned by ACS itself, consistently and reliably demonstrate that Black and brown families are targeted by the family policing system. These internal reports also demonstrate that ACS caseworkers are pressured to coerce vulnerable families to relinquish their constitutional rights before a court is even involved, or they have assigned counsel. The current system of mandated reporting unnecessarily funnels huge numbers of low-income Black and brown families into intrusive investigations without any evidence that the system actually helps families or prevents or reduces harm to children. What harms children is being separated from their families. What harms children is entering a system that literally guarantees higher delinquency rates, higher teen birth rates, lower earnings over life, I'll wrap up, increased likelihood of juvenile justice system involvement, and increased likelihood of needing emergency health care within a year of their parents being investigated. The system creates a stop and frisk dynamic that entangles vulnerable families into a system of child safety theater, where families are torn apart by the court and ACS instead of supported. The idea of an innocent person being wrongly incarcerated is intolerable to New Yorkers. That same logic should apply in this system. Even one child wrongfully torn from their parents is one child too many. New York City should have a children and family services institution that turns to prosecution and separation as an absolute last resort. But that's not what happens day to day. And it should be an institution that serves family based on the family's self-identified needs and not the needs identified by the system.
Thank you very much. Next.
Good afternoon. My name is Jennifer Feinberg, and I'm the litigation supervisor for policy and government affairs at the Center for Family Representation. Thank you, Chair Brewer, Chair Ayala, and Chair Hanks for holding these, and the committees for holding this hearing today, and considering the ways that operations of our family courts and the players who practice in it so often fail to deliver the justice and fairness that New York families deserve, and instead perpetuate racism and harm on the communities they are meant to serve. CFR is the countywide indigent defense provider for parents prosecuted for neglect and abuse by ACS in Queens and Manhattan, and as of 2022, a conflict provider in the Bronx Family Court. 90% of our clients are Black, brown, and people of color. All are poor. The 2020 report from the Special Advisor of Equal Justice in the New York State Courts found that New York's family courts provide a second-class system of justice for people of color in New York State. 3 years later, following a pandemic that disproportionately impacted these same communities, that has not changed. Black and brown families continue to be separated for too long, or even sometimes permanently, as the family court fails to administer justice. Unnecessary delays undermine the procedural and substantive due process rights of families, extending separation and making it more likely that a family will be permanently separated by termination of parental rights, given strict statutory timelines. Family Court Legal Services, or FCLS, attorneys representing ACS consistently fail to provide timely discovery and court reports and request repeated adjournments when their witnesses do not appear. ACS workers fail to make timely referrals, which delays parents to engage in their service plans, and they fail to provide reports to their attorneys. Those adjournments requested by FCLS are almost always granted, while adjournments are rarely given when a parent is not present. Long adjournments prevent the adjudication of cases and make it more difficult for families to work towards reunification. On the other hand, any absence by a parent is held against parents and seen as proof that they are not invested in their families, even if their absence is due to work or childcare.
Need to start to wrap up.
Yes. The family court itself perpetuates the harms of the family regulation system, often failing to work as a check on the family regulation system, and prioritizing adoption and family separation over what is best for children and families. Standards and goals set for judges prioritize how quickly judges complete fact findings, dispositions, and termination of parental rights cases instead of focusing on reunification and the best outcomes for families, which sometimes means giving parents more time to meet the requirements of a burdensome service plan to address complicated problems like substance abuse, which may take years to resolve. The courts repeatedly fail to prioritize emergency hearings requested for reunification, called 1027s and 1028s, which are statutorily required to be held expeditiously. Long adjournments and inadequate hearing times often cause these hearings to last for weeks, if not months.
Thank you very much. Next.
Thank you.
Thank you for the opportunity to testify today. My name is Miriam Mack, and I'm the Policy Director of the Family Defense Practice at the Bronx Defenders. One of the major challenges that impedes justice and fairness in New York City Family Court and undermines the fundamental right to family integrity indeed occurs before families ever get to court. Over 20,000 families in New York City were subjected to highly invasive, stressful ACS investigations from January through May 2022 alone. 75% of these investigations were neither indicated for neglect nor abuse. The trauma to families, and especially children, is long-lasting and well understood. Parents are subjected to invasive questioning about the most intimate details of their life, asked to sign blank HIPAA forms and take drug tests, and are forced to endure expansive home searches. Children are interviewed separately from their parents and often taken from school in front of their friends and teachers and routinely asked about a host of mature topics not yet introduced to them by their parents. Investigations cause terror and trauma that are most disproportionately borne by Black and Latina children. And to be clear, all of this happens without parents ever being told that they have rights. Not only rights guaranteed by the federal Constitution, but New York state law. This is not social work, what is happening in the homes of Black and brown and marginalized New Yorkers. This is government coercion targeted specifically at our most marginalized communities. To shift towards justice and fairness in New York family courts, We must first and foremost reduce the number of families that are targeted and surveilled and controlled and separated by the family regulation system. To do this, we have to narrow the front door by addressing systematically and systemically the largest drivers of families into the system, poverty and racism, and replacing a policing system with a system of community response and support. And to be clear, this expansion, this shift is not CARES and preventive services. That's not the answer. While described as voluntary, the CARES program is often terrifying for parents, and they know that parents know that they can't reject CARES, because a rejection of CARES means that you continue on the investigative track and the possibility of family separation. I'll wrap up. And so as we shift to reducing the system, there are other things that we can do in the interim. Number one, pass Miranda family rights, Intro 294, 2022, and 1736, 2019. It is imperative that parents know their rights when they're interacting with the government. There cannot be any justice or fairness if there's not transparency in what parents do or don't have to do. And lastly, investing in timely defense. We know as defense attorneys that having defense attorneys during the investigation can really shift away from misconception, mistakes of fact, lack of context, racial bias, all of the things that lead to so many cases being filed in family court. We know that having access to timely defense prevents this.
Thank you very much. Next.
Good afternoon. My name is Nila Natarajan, and I'm a supervising attorney and policy counsel at Brooklyn Defender Services. Thank you for having us and holding this hearing. I'm going to expand on what Ms. Mack described as our interdisciplinary representation. Along with my colleagues here, our organizations have created a robust interdisciplinary model of defense that has empowered families to make the best decisions for themselves, avoided some of the most traumatizing harms of investigations, avoided court proceedings, kept families together, and if separated, returned those children home faster. Our office provides comprehensive legal and social work services. Our teams ensure that a family's legal and non-legal needs are met. Our social workers work closely with parents, who are the experts of their lives and needs, to identify needed resources and supports, and then make those vital connections. Our advocates connect families to community-based programs and to tangible resources like signing up for public benefits and insurance, navigating complex public housing systems, and even accessing food pantries and other supplies for children. All the while, our attorneys are working on a parent's legal case, appearing in court to litigate complex trials and hearings, providing in-depth legal counsel, negotiating with counsel for ACS, filing motions to address a variety of issues such as the frequency of family time or visitation, reunifying families, and most importantly, addressing the failures of ACS and foster agencies to fulfill their legal obligations to families. As you can begin to see, our attorneys and advocates are often stepping in to support families when ACS, foster agencies, and their counsel place unneeded and punitive barriers between children, their parents, and the resources and supports they need. This model works. There is a holistic study that shows that when a family has interdisciplinary representation, New York City has saved $40 million in foster expenditures, and children return home nearly 4 months earlier than they would otherwise, without any real difference to the safety of children. And I'll wrap up there.
Thank you very much. Next.
Hi. Oh, yes, thank you. My name is Justine Lill from the Center for Justice Innovation, which has a vision of a fair, effective, and humane justice system. Operational challenges in family court unfortunately undermine this vision. The center has outlined some of the operational challenges in family court, in its written testimony, including delays in adjudicating custody and child support cases that compromise safety and the lack of diversion opportunities for youth. But I want to focus on the challenges navigated firsthand by the Strong Starts Court Initiative, a program dedicated to the especially vulnerable group of court-involved children ages 0 to 3. Strong Starts incorporates expertise in infant mental health and serves as a response to an under-resourced family court that can compound trauma for infants by causing unnecessary separations, multiple moves in foster care, and delayed permanency. These outcomes are devastating for babies because of the rapid brain development at this age and the highly adverse impact of neglect and toxic stress on brain structure and function. There are more than 10,000 babies known to the New York City family courts, and Strong Starts is able to serve only a fraction of these children. but does so effectively by mitigating operational challenges that must be addressed on a larger scale, including lack of resources, notably the lack of supervised visitation, the staggering wait lists minimize and delay child-parent contact, prolong reunification, and prevent cases from moving forward. The lack of streamlined communication and coordination amongst the many city agencies serving these children and families, also causing incredible delay. Staffing shortages across the system, rendering needed supports unavailable. All families, especially those with young children, deserve a family court that offers support and is a catalyst for positive change. Family court has an incredible opportunity to intervene at the earliest entry into the justice system and respond effectively and efficiently to the needs of New York City families. Operational challenges can be addressed and mitigated with programs like Strong Starts, which work to transform a court system that can exacerbate harm into one that improves outcomes for families, minimizes trauma for young children, and reduces future system and court involvement. Thank you.
Thank you. I just have one overall question, because first of all, thank you for your service. People say that to me, but I really mean it to you, not to me. And the reason I ask is these are in my opinion, the families that need the help the most in entire of New York City. And others, particularly Councilmember Ayala and Williams and others asked about the holistic approach, which you're talking about. In other words, why in the world can we not bring the Department of Education and others to do the kind of work before young people end up in the system? So did this discussion ever take place, et cetera, from your experience? You're trying to deal with it once the problem exists, but do you have any discussion, or is there any discussion from your experience about how to have prevention in the first place?
Thank you for that question, and it's very good to see everybody in 3 dimensions. Usually we're in these hearings on screen, and so it's good to be here in person. I think from my perspective, this is a question of mandated reporting. I think the system of mandated reporting has been punitive and prosecutorial since its inception. And I may get these numbers slightly wrong, so I'll ask my colleagues to correct me if I'm wrong, but I believe something like 40% of the calls that come into the State Central Registry come from the DOE, and something like 80% of those are unfounded. So there is no structural support for families who are struggling and whose children are going to the DOE for their schooling, right? And we all know that families in New York City who are living in poverty or just above the poverty line are really struggling. And there's lots of basic things that a school could do to help instead of calling in a case. And from our experience, including the experience of some of my staff who themselves are impacted parents, these calls are often made retaliatorily. So there's legislation that the City Council can support, and I don't have the numbers with me, and I'll try to get them to you, but that would prohibit anonymous reporting, right? And where it would be confidential, but the anonymous reporting would be prohibited, so the people who are making the calls would have to be accountable, right? And I want to come back to this question that has been asked, and I think it's part of what you're asking, Chair Brewer, about communication. I think there are lots of really wonderful ideas and projects and thoughts and perspectives coming from the upper level. I think Councilmember Williams was saying this earlier, right? Oh, it's Stevens. Oh, I'm sorry. I'm looking at I couldn't see from back there. All right. I also just couldn't really see very well from the back, so I apologize. But what ends up happening is that there's no accountability, there's no trickle-down effect, there's no accountability on the ground level. People may not be talking enough on the top level, but there sure isn't any accountability or communication on the people towards the people on the ground, right? I've been doing this work since 2011, and since then, I have always heard really inspiring, really hopeful, very progressive things from the commissioners of ACS. I have never seen it on the ground. And to this day, I go to court at least once a week. I supervise intake at least once a month in the Bronx and in Manhattan, and we see the continuous sort of like lack of application of ACS's own policies that are that are supposed to be pro-reunification, pro-family, pro-parent, but instead we see just so much punitive perspective, absolutely no compassion, and just a lack of understanding of what it's like to be a low-income parent in New York City.
Anybody wants to add to it, but Councilmember Ayala, go.
No. I was going to ask a question regarding the mandated reporting at the DOE. Is there any level of education from ACS to those mandated reporters in specific that, you know, better informs them of what an appropriate, you know, referral is?
Thank you for that question. And so I know that OCFS has taken steps to really sort of readjust and talk about mandated reporting and sort of shrink or at least clarify that mandated reporting is not as broad as people interpret it to be. But I think that we would submit that it's not just about training, but it's actually shifting away from the structure of mandated reporting, because what mandated reporting really does is it turns the social service providers that families, especially vulnerable families, need to be able to rely on and trust, and it turns them into extensions of the family policing system. And so as a result, what it means is that parents are fearful, and their children are fearful of interacting with these service providers, whether it's teachers, it's nurses, it's doctors, and it has an effect of creating almost an adversarial system between these social service providers, which are critical for parents and critical for families, of course. And I really want to lift up the work of the Narrowing the Front Door Coalition. They have put forth recommendations, really a pathway to move away from mandated reporting. And also, I think there was a question earlier about, is there money that we can be investing in the family instead of the family regulation system? The mandated reporting infrastructure requires massive amounts of money. And so if we moved away from mandated reporting, we could put that money into schools, into our communities, into parents, so that instead of having to, you know, rely or have the false notion that ACS is going to provide resources, which they don't, schools will have resources embedded within them. Communities will have resources, families will have resources.
Could I answer a little bit more concretely? Actually, Ms. Mack's answer was excellent and very concrete, but I have a 6-year-old who goes to PS 516 in Brooklyn, and I am on the school leadership team, and I'm in meetings with ACS where they're talking about training DOE, where they're talking about, you know, how to make sure that mandated reporters in schools don't make frivolous or false or harmful calls. And then I'm going to the SLT meeting and saying, and they said that, you know, everybody's been trained, and the principal and the vice principal haven't heard of this, right? So again, there is a trickle-down problem where there are all these really wonderful ideas at the top, but there's absolutely no accountability or like revisiting of how these or assessment or of evaluation of how these like great ideas are actually playing out on the ground.
I think it's a little, you know, as a parent, as a person who has seen and somehow been involved in the system in many, you know, different ways, is a really scary process. And I don't think that, you know, especially if you're in a school and a child is coming in and looks like they haven't eaten, right, or they have bruising, then somebody, right, should be paying attention and monitoring that case. And I agree with you. The ACS system is very punitive and very scary. And I've had that knock on my door, and I've been innocent, and I'm scared. You know, I'm not gonna say what the other word is, because that's how we've been ingrained, right? Like that feeling of what ACS means, right, to a family or could mean is traumatizing, whether you are, you know, a great parent or a struggling parent. It doesn't matter. So I get that, but I also believe that there has to be some mechanism to track, you know, those cases where those parents need a little bit more support. And I think that that's why, you know, it's important to have that conversation with educators, because if we're talking about a family that cannot afford uniforms, right, then maybe we should be supporting that family as a school community, right? Maybe, you know, we could, as elected officials, put in resources to create, you know, some sort of little store where kids can come in for free, right, if needed, and have access to that. But if a child is coming in malnourished, if a child is coming in and has signs of, you know, physical abuse, then who do we refer those cases to, and how, you know, do we differentiate between the two?
Yeah, I think oftentimes the question is a question of, it's rare that it gets to those cases.
Yes.
The number of times that I'm sure all of us have seen cases where a child goes to school once or twice and says, I'm hungry. And we all know when children are growing, they're hungry all the time. And also, for example, my daughter's lunch is at 10:20 in the morning, right? So the timing might be part of the issue too, right? But we've seen, all of us have seen so many cases where a case is called in and allegations of neglect are made. They get all the way to that point of filing something in court because a child came to school and said, I'm hungry. When the solution is so obvious and clear. Give that child food. Give that parent a gift card to, or tell them where the food pantry is, right? It doesn't have to get to a point of investigation. And I think the culture of mandated reporting has become this knee-jerk response, right? And we've talked with, our organizations have talked to educators and to medical professionals where they say, like, we have been trained, shoot the gun and put it down and don't look what happened next, right? They're not given any training on the actual impact of mandated reporting, and how children are strip searched when their parents are being investigated, how, ACS has the ability to seek a warrant in court, but never does. They do it in something like 0.7% of their cases, right? And that parents have rights based on the Constitution, New York State Constitution and the state laws, to say no and to make decisions for their own family. And I'm so sorry that you've gone through an investigation, but as you're saying, it's part of the culture, right? That you are scared, and I won't say the second word either, when somebody comes to your door. So you just do whatever you have to do. But what most parents don't understand is that when ACS comes to their door, they have rights, and they don't have to go through this interrogation, and they don't have to reveal every tiny private thing about their lives that then is used against them. Yes, my child is hungry sometimes, but because they're going through a growth spurt, that doesn't mean I'm harming my child, right? And of course, children are harmed regardless of where we are on the economic spectrum, right? That harm is part of society. Harm is part of culture, right? We can't get rid of it. But what do we do when it happens in a community where there aren't resources? We should do the same thing that is done in a community where there are resources, which is provide excellent care for that family, provide support for that family. Don't separate them. Don't put the children with strangers. Don't prosecute the parents, right? All of that is a wild overreaction, right? Somebody else testified, I think even it was the commissioner, that a very high number, and I looked at the numbers recently, I think about 50%, if not more, of foster system entries are for neglect, right? Not for abuse. And so the whole system's priorities are upside down, and we really there needs to be accountability for ACS. I know this body can't really do a lot to hold the family court accountable, but has to be.
That's a really good point. I mean, just understanding, right, that such a huge percentage of the cases are for neglect. Right, that's important to me. For me, it's also really important that we're balancing the scale in a way that is fair, that is equitable, that is taking into account, right, poverty and all of the other underlying issues that contribute to a lot of these cases, while also not neglecting, right, the fact that there are some cases, as small as they may be, of instances where children are at risk, where they, need some level of intervention. And I'm not at all advocating for removal, but if that's necessary for that child, right, there has to be. And I think that often in government, and what I've learned sitting in the city council, is that we see a lot of, I'm a lot of this, or I'm a lot of this, right? And then there's a lot of nuance in the middle that doesn't get addressed because we're so passionate about one thing or the other. And it's, you're absolutely right. Years and years of, abusive tactics and inappropriate reporting models and the way that we address these issues. I get all of that, but I just want to make sure that even if it's that 3%, 2%, whatever that small percentage is of children that are at risk, which I've seen and I know. I had an instance many years ago when I was a tenant and my next door neighbor was a victim of domestic violence, and I tried to help her. I didn't know what to do, and I finally, the last straw, it was like 5 o'clock in the morning, her husband beat her severely, and the children were always there, and her daughter had become the mother, if you will, right, the caregiver to the rest of the children, and she must have been 8 years old. And at that point, I had no other choice. I had to call somebody so that they can come and make sure that those children were okay, and that mom received the services and the care. And I think that's the problem, right? Is that we're calling with one intention, and then something else happens. And I'm more, really focused on what happens after that call is made, if it has to be made, right? And in that case, I really felt that it was necessary to call, and I think a lot of people, do as well, and but okay, I really appreciate it. This is really, really, really.
Can I just add one thing, that 10% or less of cases are abuse cases, and imagine the 90% of cases that are neglect, that all of the resources that go into those cases are then not used on the cases that you're describing, right? So I think there has to be a reorientation of priorities.
And I just want to add that saying that we need to reduce mandated reporting or get rid of the mandate doesn't mean that either you in that situation or a teacher in some sort of dire situation couldn't still make an assessment, a meaningful assessment that respects the family and call a report. Now, I wouldn't condone that, but getting rid of the mandate allows that teacher to pause and think about it and really make an assessment that's in the best interest of that child and their family, as opposed to fearing loss of their job or employment or licensure or whatever they're fearful of. They can make a better, more informed decision that's really about the well-being of a child and not their own fear, frankly.
Yeah. No, I appreciate it. Thank you guys so much.
Thank you.
Councilmember Williams, did you have a question?
Yeah, what was the organization you said that was working on a process, Front Door?
Yes, it's the Narrowing the Front Door Coalition. Narrowing the Front Door, and they have a report online. We can provide the report and the contact information.
Okay, and I typically, I try not to, talk about my personal experiences, just, listen to you guys, but something that you said made me think of a story. My mom was a caseworker for ACS for 36 years, and she told me about lots of stories, but one of the stories that I thought about was one day she told me she had to do an investigation, and they had mattresses on the floor, which is, at that time, I don't know if that's still the ruling now, this is early 80s, that was, a violation. She could have removed the kids because the mattress was on the floor, but she essentially disobeyed the rules because she's they have beds and there's food in the fridge. And so I'm just thinking about how a lot of frontline workers do have this discretion and or the lack of the discretion because they don't want to lose their jobs, and how that can impact what happens after a call is made. So in this case, it was a situation where they said the child was hungry. And when she went to go visit, she's like, well, there's food in the fridge. And yeah, the mattresses are on the floor, but they have mattresses, they have a place to sleep. And that's just because of her own experience growing up in public housing and understanding what it means to live in poverty. But I feel like that's really not how the system treats our children. And then I just had a quick question about the discovery. Are you seeing discovery issues on your end when you're trying to defend either youth offenders or parents who are being prosecuted for a neglect or abuse case?
Yeah, I guess I can address that. So for our youth defense practice is a little separate, but I'll answer for family defense. We're consistently facing issues with discovery where it can take years, literally, to get discovery on a fact finding. So we can't go forward to a trial to adjudicate whether or not there was neglect in a home. I've had cases go on for 3 years, and the reunification of that family, it was let's say it's an abuse, I had an abuse case, it went on for 3 years because of lack of missing witnesses, lack of discovery. Finally, at the end of the trial, the judge dismissed the abuse, and my client's kids were allowed to go home immediately. So why were we waiting 3 years to get those children home? There was no safety concern, right? So these sorts of, yes, we're consistently seeing lack of discovery or getting discovery at the very last minute, which also makes it very difficult for us to be prepared and to do, zealously advocate for our client, which is our responsibility.
I would say, to add to what Ms. Feinberg is saying, is discovery is late, settlement offers are late, reports and information from agencies and ACS is late. It puts us, families, in the position of not being able to make fully informed decisions for their families, including in the course of a trial. So, if I don't have discovery timely, then counsel for ACS can come to court and say your client should take a plea, essentially, so their children can be returned home, or we can do this trial for the next 6 months. And one, that's inappropriate because I believe that if ACS believes a child can go home, that child should go home regardless of a parent's decision to take a neglect finding or what have you in court. But secondly, it puts a parent in the position of they have to take that loss for their child, as opposed to getting a fair chance at actually litigating that trial, defending themselves, and perhaps walking away without that on their record. But they're not given the latitude to make a really informed choice. They have to decide between their children and, a finding.
Yeah, the state laws on discovery, does that impact family court, or was that was just for criminal court? So those laws don't even apply to family court proceedings?
They also don't apply to some of the youth defense cases as well, which is difficult because actually youth who are diverted are not receiving, they're not getting the same speedy trial and the same discovery turned over in the way that they would in criminal court. So they're actually, in some ways, it's detrimental to them, at least from the litigation perspective and in our ability to get that discovery and move the case forward.
Thank you all very much. Next panel.
Thank you.
Thank you for your testimony. We'll now hear from Rachel Bronstein, Stacy Schechter, Karen Simmons, and Joyce McMillan.
Go ahead, thank you very much.
Thank you so much. Thank you, Chair Brewer and the Council and the Committees on Oversight and Investigations, Public Safety, and General Welfare. My name is Rachel Bronstein. I'm the Director of Policy at Her Justice. For 30 years, Her Justice has stood with women living in poverty, working in the areas of legal services in matrimonial, family court, and immigration matters. In 2022, Her Justice provided help to more than 5,300 women and their children, and we are dedicated to helping women in family courts, which they must access for legal relief that can provide essential security and stability to them and their families. We're grateful for the Council's support for these issues. Women living in poverty, particularly Black and brown women, are forced to rely on the civil justice system that, as we've discussed today, has been historically and systemically under-resourced. While the family court system was originally imagined as one without lawyers, over time the process has become so complicated that those who are unrepresented often come up short. The COVID-19 pandemic certainly brought into greater focus existing challenges in the family courts, but it also set the stage for possibilities for future improvement. More than 3 years after the start of the pandemic, the New York City family courts have not fully resumed normal operations, creating significant confusion and uncertainty for litigants. I'm just going to highlight very briefly 4 issues. One is the need to address backlogs and delays. Just as an example, child support is a critical issue, especially for custodial parents, but the inefficiencies are critical for all families. There are typically 200,000 filings for child support in the New York family courts, which means there is a great need for this help. But at the start of the pandemic, child support was not deemed an essential case type, so families couldn't file for relief. Today, there remain unacceptable delays, which of course impact families in terms of financial support, but also in terms of missed days of work, extra childcare costs, etc. Similarly, custody cases were not deemed essential at the beginning of the pandemic, and so families waited for the court's help to sort out parenting access arrangements, which impact families greatly. I'll wrap up and rely on my written testimony. Thank you for the time.
Thank you very much. Next.
Thank you for the opportunity to provide testimony at this hearing on New York City Family Courts. My name is Stacy Schechter, and I have spent my 13-year career in family court, first at ACS, then as a court attorney to a family court judge, and now as Director of Legal Services at Safe Horizons Domestic Violence Law Project. Safe Horizon is the nation's largest nonprofit victim services organization, offering client-centered and trauma-informed response to 250,000 New Yorkers each year who've experienced domestic violence or abuse. Domestic Violence Law Project assists with orders of protection, custody, child support, and uncontested divorce in the family court and Supreme Courts. We run a legal helpline for DV survivors, and we provide assistance in all 5 borough family courts via the Family Justice Centers and our family court program. So we understand what practice in family court is and what it lacks. Today, Safe Horizon would like to just highlight a few points. One, funding for attorneys. To help ensure that DV survivors are successful in seeking orders of protection, custody, visitation, and child support, they need attorneys who understand the complexities of domestic violence, which can be not only physical, but mental and emotional as well. Survivors need attorneys who understand how abuse victims behave after prolonged trauma, how trauma bonds cause survivors to return to the relationships, and how abusers often engage in the tactic of litigation abuse. Survivors need particularized assistance in navigating our family courts, but free and low-cost legal services are incredibly limited in New York City, and as such, so are the chances that survivors will receive representation from a trauma-informed practitioner. City Council funding via the Safe Alternatives to Violent Encounters Initiative helps ensure that Safe Horizon DV Law Project can offer expert legal services to low-income survivors
in the city's family and integrated domestic violence courts. This essential funding, which also supports our colleagues at Sanctuary for Families and Her Justice, must be fully restored in the fiscal year 24. And to help sustain the health and vitality of Safe Horizon and our colleagues in the nonprofit legal services community, the city must also include a 6.5% cost of living adjustment in the final city budget. And I will rely on the rest of my written testimony that we have submitted online. Thank you.
Thank you very much.
Good afternoon. Thank you for this opportunity to the chairs. My name is Joyce McMillan. I'm the founder of JMAC for Families, and I'm a co-chair for the Narrowing the Front Door alongside Angela Burton from OCA and Kristen Morse, the director at the Center for New York City Affairs at the New School. I just have a couple of quick points I would like to make, nothing that I'm reading off. Commissioner Danhauser mentioned during his testimony that they have reduced court filings to almost half, but because they're not filing court cases don't mean they're not intruding on the same number of households and terrorizing the families. And it's actually even more dangerous because there's no oversight and families are just going along with whatever ACS is directing them to do out of fear. A family can be under ACS partners with a lot of people. We were asking questions about the people who was testifying with them earlier and what does their partnership look like. The problem is the partnerships are only designed to create surveillance of the families, not to figure out how they could best serve families. And they would never partner with Whole Foods or Tide or any of the regular things that people need. And when we talk about mandated reporters, the problem of having mandated reporters is that we all want children to be safe. Even though I'm a staunch advocate against child welfare, family policing, I understand that children need to be safe. But having a mandated reporter will never help us to accomplish that. Because if you're a mandated reporter and I'm in need of assistance, who is it that I can go to when everyone that has a professional involvement in my life is mandated to report me? It creates a fear and it makes me go inside of a shell and not ask for the help that my family needs. If allowed, may I please just make a couple of other points so I can clarify for some of the things that were said. OCFS and ACS continue to say that they're trying to train people to the point where there won't be over-reporting by mandated reporters. The way to train them is not to spend a lot of money on trainings, but when they call and they know the call does not rise to a level that they should be reporting, just tell them they will not take the report and save that money and put it into the communities. Everything that's hurting families and everything around the courts are falling apart, the court building itself. But no one at ACS or these foster care agencies are taking a reduction in pay. Judge Ron Richter asked for an increase in the pay of the 18B attorneys who show up to court and only see their clients for the first time 2 minutes before they enter the courtroom. But everyone's being paid. Children are changing homes using garbage bags. But you have foster care presidents making over $500,000 a year. It's an atrocity and it's a disrespect to families, communities, and elected officials who give them the benefit of the doubt as they continue to promise change and never change. It's been decades. I was impacted 23 years ago, and they're still doing the exact same thing today that they were doing 2 decades ago.
Okay. Thank you very much for your testimony, all three of you, and every person's testimony will be taken seriously. I'm going to do follow-up. Thank you very much.
Thank you very much.
Thank you for your testimony. We will now be hearing from people on Zoom. We'll be starting with Kathy Kramer. For virtual
I'll call you back. Goodbye.
For virtual panelists, once your name is called, a member of our staff will unmute you and the Sergeant at Arms will set the timer and give you the go-ahead to begin. Please wait for the Sergeant to announce that you may begin before delivering your testimony. So I will now call on Kathy Kramer, followed by Lisa Freeman, followed by Dr. Sophie Charles.
Time starts now.
Care, many of you organization in New York dedicated solely to working with parents and caregivers who don't have lawyers when they come to family court, primarily in child support, custody and visitation, parentage, domestic violence and guardianship cases. Thank you so much for the invitation to testify today. I just hope it's the beginning of a public conversation that is overdue. I want to make clear I am not disparaging the personnel of the family court. We work very closely with the courts and know they're doing their best with very limited resources. The family court is supposed to be a place where you can get justice without an attorney, but 80% of people come to family court without a lawyer. The reality is that it's a very complicated case and some legal support is essential. In addition, family court serves low-income families and people of color. It's perceived as a second-class court. Fixing the family courts is a racial justice and equity issue. We have several recommendations which we cover in more detail in our written testimony that I encourage you to read, but here are just a couple. The courts need more funding to hire additional jurists and support staff. They've been understaffed for ages and decades before, during, and after the pandemic, and this hurts child custody, child support, and all the issues we work on. There needs to be standardized procedures across the family court system. Right now, jurists have their own procedures. Litigants are not told about them at the outset, and so many cases get dismissed or adjourned on technicalities. The courts need to prioritize child support. It's a poverty prevention tool that can help prevent other issues from ever reaching the family court, including what we've been talking about today: child welfare, juvenile justice, all these issues. The courts need to increase universal case management system and access to it. It needs to upgrade its outdated technology. The website is terrible and it needs to move up on e-filing. And the virtual hearings are great for people who have technology, but for the people who don't have technology, the court has to address their needs. The digital divide is real. Our clients are navigating highly emotional issues involving family stability, relationships, and finances. Strong families are essential to the future of our great city, and addressing the challenges of pro se litigants in family court is vital to increase access to justice.
Thank you very much, because your 2 minutes is up, and your staff has been wonderful here today. Thank you, Kathy Kramer. Thank you.
Okay, thank you very much, Gail Brewer.
Bye-bye.
Bye.
Thank you very much for your testimony. We'll now hear from people from Lawyers for Children.
Time starts now.
Thank you very much. I am going to put aside my testimony so I can speak quickly to points that have not yet been raised. My name is Karen Friedman. I'm the founder and president of Lawyers for Children. We've been practicing in the New York City family courts for over 40 years, and we're representing 3,000 children a year in a holistic representational system. We have attorneys, social workers, and youth advocates representing our clients in foster care, abuse, neglect, custody, termination of parental rights, delinquency cases. And it was you, Chair Brewer, who brought up at the very beginning the fact that the responsibility for funding our organizations, the Attorneys for Children law offices, the nonprofits throughout New York State, there are 11 of us, that falls under the judiciary budget. So why am I here bothering you? In New York City, over 90% of the children in family court are represented by Attorneys for Children's law offices, nonprofit law offices. We right now are sitting with a 10% budget cut that was put in place at the beginning of the pandemic and has not been changed since that time. That is in addition to over close to 20 years of flat funding for AFC offices. And why does this happen? This happens because The voices of children are often ignored, and that's what our office is dedicated to prevent. I so appreciate your focusing on the family court, and I would ask you, I would beg you to do one thing that the City Council can do, which is to contact Senator Hoylman and tell him that the City Council needs funding for attorneys for children, 90% of whom are here. I'm sorry, we have very long testimony. Just have 1 minute from my colleague.
Go ahead, yeah.
Thank you. My name is Anna Schissel. I am the Deputy Director of Litigation at Lawyers for Children, and I would like to just make a couple of additional points about operational issues on the ground. We urge the City Council to improve family court operations by embracing technology. As you have heard, remote proceedings have dramatically improved the court's efficiency. When participants are able to appear by video, fewer cases require adjournment, and more people have the opportunity to participate. The need for remote access to the courthouse is made even more acute by the shortage of security personnel. Physical altercations between litigants in the family court hallways are sadly not uncommon. Since the resumption of in-person proceedings, the number of officers in Manhattan Family Court has dropped precipitously. There are no officers in the rooms where referees preside over custody and visitation matters to provide protection from an emotional and angry litigant, and some floors in the buildings do not have a single officer on the floor to provide assistance. Ironically, this means that victims of domestic violence who come to the courthouse seeking orders of protection cannot be assured that they will be safe in the building. Being able to participate in court proceedings from a secure location is essential. We urge the City Council to ensure that there are additional technology hubs throughout the city to ensure that litigants can meaningfully participate in family court without having to travel to court. In addition, if all children in the New York City public schools were guaranteed both access to hardware and home-based Wi-Fi, it would not only level the educational playing field, but ensure that every child with a family court case could appear remotely without missing school and participate effectively in these court proceedings that so drastically impact their lives. I would ask the council to please refer to our written testimony regarding increasing access to supervised family visitation programs. And finally, we would urge the City Council to improve family court operations by addressing the in-person mandate. Family court operations have been significantly hampered by the frequent turnover among ACS attorneys and caseworkers. The number of ACS attorneys in Manhattan Family Court has dropped by nearly 1/3 since March 2020. We've been told repeatedly by departing attorneys and caseworkers that the mandate to be present in the office 5 days a week, even when they could effectively work from home, is a significant factor in the decision to leave ACS.
Thank you very much, both of you. Thank you so much.
Thank you very much.
Thank you very much for your testimony. If we inadvertently missed anyone who would like to testify in person, please visit the sergeant's table and complete a witness slip now. We will now resume Zoom testimony. We will first hear from Lisa Freeman, followed by Dr. Sophine Charles, followed by Darlene Jackson.
Time starts now.
Good afternoon, Chair Breyer. Thank you so much for holding this lengthy hearing. As you can see, there are a lot of issues that, I'm not sure if the audio just started. Thank you so much for holding this lengthy hearing. As you can see, there are many issues that touch on family court. It's a complicated system and very dysfunctional system. My name's Lisa Freeman. I'm the director of the Special Litigation and Law Reform Unit in the Juvenile Rights Practice of the Legal Aid Society. We represent the majority of children whose parents are charged with abuse and neglect in family court. In addition, we represent the majority of children who are charged as juvenile delinquents. So in addition, the Legal Aid Society has a civil practice that represents survivors of domestic violence, handles orders of protection, custody, visitation, child and spousal support, as well as contested and uncontested divorces. So we have a lot of experience in the system in all 5 boroughs, and we will be providing extensive written testimony. So I just wanted to highlight a couple of issues now. The first, since no one has really spoken exactly from the perspective of representing juvenile delinquents in the system, I wanted to mention that there is a significant shortage of staffing for ACS's Division for Youth and Family Justice, and that as a result of that, the arraignment process is delayed for many youth. that process implicates, not just the lawyers for the children and the children themselves having to be in custody longer than necessary, but all the other players that have to interview the youth in the courthouses. So often during arraignments, people are waiting for the DYFJ staff to arrive in order to move forward. And it's unacceptable. In addition, kids from this same staffing shortage, kids in detention are being deprived of access to school on occasion. We have several reports where there are no escorts available, and so children just are not brought to school. Again, that's obviously not acceptable.
You need to try to wrap up. Thank you.
Yes. So I wanted to mention there's been a lot of discussion of technology, which obviously has helped many, many stakeholders in the system. We would advocate for an evaluation to be done that hears from actual impacted parties, the children and parents that are affected. Without that, I think we really, it's difficult to know who is benefiting and under what circumstances from this technology, which obviously needs to be improved as well, but we think an evaluation would be essential. I also, there was discussion about cost earlier. The cost of congregate care for children in ACS custody is enormous, something on the order of $280,000 a year. And so that's one circumstance in which we think it really would be beneficial. The federal legislation was intended to reduce the number of children in congregate care. All too often, kids wind up institutionalized and at great expense when that money could be better spent. Finally, I would just reiterate the issue with regard to UCMS and access, that we need to coordinate with the state. We are being deprived full access to the UCMS technology, which interferes with our ability to represent our clients. We don't get access to all dockets that our clients are involved with, and we don't get access to all documents. And that's obviously just not appropriate, and coordination with the state and pressure on the state to change that would be beneficial. All right, thank you very much.
Thank you very much.
Thank you for your testimony. We will now hear from Dr. Sophine Charles, followed by Darlene Jackson, followed by Tanisha Grant.
Time starts now.
Good afternoon, council members Ayala and Brewer. Thank you for the opportunity to testify. I'm Dr. Sophine Charles, the Associate Executive Director Downstate for CAFCA, the Council of Family and Child Caring Agencies. We represent over 100 agencies statewide, providing foster care, adoption services, family preservation, and juvenile justice. We represent more than 50 agencies in New York City. And I'd like to begin by first acknowledging and recognizing that there are collaborative efforts that are already underway between the ACS legal team, the Administrative Judge Jolly's office, and provider agencies. We applaud ACS legal team and Judge Jolly and the family court staff for their willingness to convene regular meetings with agencies to collect data and feedback and review recommendations for how to increase outcomes for children and families. Today, I raised 3 areas of concern from the provider, agencies, and families' perspective. Number 1 is scheduling barriers across the various court hearings and proceedings. Number 2, unrealistic court orders presented to case planning teams, and staffing challenges across all levels and the stakeholders, caseworkers, FCLS attorneys, and judges. And I'll say that the fact-finding proceedings are significantly delayed, which thereby delays all other advancements of families through the court system, and that on the side of unrealistic court orders, agencies are required to infuse resources into helping families through the system. They have limited budgets, limited contracts, and they are required to pay for mental health evaluations for families and parents without insurance. They're required to transport children across the city to different boroughs, And all of this absorbs time of the caseworkers and resources of the agencies that are not reimbursed. And I'll also just mention the staffing challenges hugely impact the agencies. Provider staff have limited access to transition planning. FCLS attorneys leave and they're delays in judge assignments to cases.
Thank you.
And all of this means that the agency staff are challenged with trying to navigate and assist families in advancing the cases through the system.
Thank
And
you.
I'll rest on 4 recommendations. One is that the implementation of technology upgrades are definitely needed in the family court infrastructure.
You need to wrap
Case
up.
family
Just-
planners and families support remote methods to navigate the proceedings and to consider the use of mediation for
Time
cases
expired.
that do not require mandatory oversight. We need to invest in more opportunities for mediation as an alternative. And my last 2 recommendations are that there needs to be a system for collecting data on the lengths of stay in foster care that result from extensive delays attributed to the many scheduling barriers, adjournments, and stagnations in the court process. And the last one is there needs to be data collection on the average time it takes to advance cases through the fact-finding process. Fact-finding is a fundamental process in the system, and when there are delays there, the delays extend throughout the system, and often the agencies take the hit for delaying and advancing families through the termination of foster care cases.
Thank you very much.
Thank you for the opportunity to testify.
Thank you very much.
Thank you. We will now hear from Darlene Jackson, followed by Tanisha Grant, followed by Jennifer Blanco.
Time starts now.
Yes. Thank you to all 3 committee chairs for today's critical public hearing. I did want to defer my time to my younger sister, Jennifer Blanco, a impacted parent and has experienced the foster system. But unfortunately, the ACS CARES program is conducting a home visit as we speak. My family continues to struggle with generational trauma and now impacting my sister's children, in which the ACS CARES program does not address or mitigate. Instead, I will submit a written testimony, but want to emphasize the following. As we collectively demand to fund fairness to improve the operational challenges of family court, and in my experience as a client advocate at the Neighborhood Defenders of Harlem, New York City Council should provide quarterly evaluations of our public defense organizations throughout New York City to ensure that they are in fact implementing an abolitionist framework and not an extension of the family policing system due to inadequate daily practices, support, and representation towards positive outcomes in and outside of the family court. We need our public defense orgs equipped with the necessary tools to lead by action and not rhetoric. That also includes traditional child welfare advocacy organizations. Thank you again for centering the disparities within the family court system and focusing on investing in families and communities. Thank you.
Thank you very much.
Thank you very much. Last call, if we inadvertently missed anyone who would like to testify in person, please visit the sergeant's table and complete a witness slip now. Turning back to Zoom, we will hear from Tanisha Grant, followed by Jennifer Blanco.
Time starts now.
Hello, my name is Tanisha Grant. I am the Executive Director of Parent Support and Parents New York. Today, thank you, Chair Gale, Councilwoman Brewer, for having this very important hearing. I come to you today not only as a community organizer, not only as a parent advocate, but as someone who was impacted by ACS, by the family court system, by the family policing system at birth. I'm 47 years old, and I'm sad to say that in the 47 years that I have been just trying to find out where I came from because of a system that decided to separate me from my entire family, that things have not changed. On here, I hear people saying the same thing that they have said for decades, but yet nothing changes. On the ground, we don't see any of these wonderful ideas that ACS is talking about. We don't see any of these tactics to keep children with their families. As a parent advocate, when I go with parents to family court, it is horrendous to us. It is traumatic for parents to have to go in them horrible buildings that the city owns, that city council for years and for decades have not seen to make it a #1 priority to have them fixed. We know that most people that go in there are Black and brown, and it is unacceptable. It is unacceptable at 47 years old. I am still trying to find my family. I cannot tell you the generational trauma that me and my children suffer at being separated by a system that continuously keeps the power to keep separating us. I am very disgusted to see white people, especially white men, sit here and talk about my life when they will never understand what it is like to be separated as a Black child from your whole family. All of these nice resources that you say that we have, I've never seen it in my 47 years. I was an adopted child that was a failed adoption that was thrown back into the system, into the foster system at 11 years old. And again, I advocate for parents and children that this continuously happens to today. So when we talk about community-based organizations and who's really on the ground doing the work, my community-based organization is on the ground doing the work every day because I am a lived experience expert in what I do. So I really ask you guys to really think about who you are funding, how you are funding them, and who's really on the ground supporting these people when ACS comes to their door and when they have to go to family court. Thank you for listening to me. I yield back.
Thank you very much.
Thank you. We have one more person who has signed up to testify in person. If we inadvertently missed anyone who would like to testify virtually on Zoom, please use the raised hand function in Zoom, and we will call on you in the order of hands raised. First, we will hear from Brian Zimmerman.
Thank you, chairpersons, for giving me this opportunity. I'm Brian Zimmerman. I'm the president of the Kings County 18B Family Court Panel, as well as the New York State Assigned Counsel Association. I'm not going to touch on a lot of things. I know it's late in the day and time is pressing. I want the chairperson to know that last week the mayor appointed 5 more family court judges. I think that got missed this morning. But I want to focus on just one area that I think that it is correct that a lot of the numbers have gone down, as ACS reported, as Corp Counsel reported on juvenile delinquencies. The one area where numbers really have not gone down is custody, visitation, order protection, support cases. And we've heard a lot about diversion today, a lot of diversion programs. These are areas I believe the City Council actually can work to fund, and so I would encourage the council to also, and I talk about this in my testimony, look at how we can stop cases from getting to court by use of mediation in every kind of discipline. It's not just child protection, it's not just the delinquency matters. There is mediation that could be made available for families in need on custody visitation matters that bring them to court, and once it gets to court, it gets highly litigated. And if we can find ways to create those kind of opportunities, and in support cases, I mean, many of the litigants that come to family court don't have a lot of money, so they're actually fighting over real things. It's fighting over food on the table. We're fighting about orders that they can no longer pay, and all the parent that has the children wants is to see some of the money. How can we work to make that a better thing, and funding those kind of programs would really help. I just also want to stress the use of remote technology has really assisted, I believe, the courts. And you heard a little bit about it from some of the other stakeholders. For our clients who often can't afford to take days off to come to court, they often can appear. The person on the child support case can't take a day off, but they can come, and you get better orders, one that reflect what can be actually paid, and that really does help the system to have those kind of help for the litigants in a focus. And Family Court Administration has really understood for the disproportionately impacted communities that more flexibility about coming to court is actually beneficial to the system as a whole. So that is another area I wanted to trust. And in terms of something the city can control, if you come to something like Brooklyn Family Court, there are no outlets for people to charge their phones. There's no places within the building. The Wi-Fi is not good. It might be true in the other boroughs.
It is.
That is something.
It's bad everywhere.
That is something that I think should be or could be addressed. And maybe Ms. Kramer said it, remote locations that are in the communities so that people can appear in that fashion would also be a great assistance that I think the council can assist with.
Thank you very much. Thank you for waiting.
Thank you. We have now heard from everyone who has signed up to testify. Once more, if we inadvertently missed anyone who would like to testify in person, please visit the sergeant's table and complete a witness slip now. If we inadvertently missed anyone who would like to testify virtually, please use the raised hand function in Zoom, and we will call on you in the order of hands raised. Seeing no one else, I would like to note that written testimony, which will be reviewed in full by committee staff, may be submitted to the record up to 72 hours after the close of this hearing by emailing it to testimony@council.nyc.gov. And I would like to turn it back over to Chair Brewer.
Thank you very much. This hearing will conclude, but I do want to thank everyone who participated, and I want those stakeholders from the administration, from the community, from everyone who's interested in this topic. This is just the beginning of a longer conversation, and we are very serious about trying to address the issues that were brought to our attention today. Thank you very much.